Attempt to mention that Lordship petition number 28674 of 2021. Yesterday, the matter was argued by Lawrence General Advocate SP Mr. Sir. Lordship allow the amendment application and directed to file the consolidated petition. Lordship, we have already filed and praying for tomorrow.
17 तारीख अच्छी परा लिखा है 17 हाँ
तो ठीक है देखने बस नॉट
ऑलरेडी डेट फिक्स है
ऑलरेडी यू कैन साइन फॉर सेलोनी से डेट फिक्स ऑफ है ठीक है फुल देखिए दे आई देखिए कि डेट पर है
But grand acquisition matter में petition's application for employment evaluation has not been considered.
प्लीज गिव इट
Case admission read appeal matter.
Read application. Case admission for withdrawal only. Withdrawal.
One matter read appeal 2020 relating to appointment of Anganwadi worker. Pleadings completed.
Read appeal of 2021.
Supplemental list, item number 1.
Yes, your Lordship, by order dated 2/12/21, directed me to produce the certified copy of the decree and the appeal memo. But I have not been able to get the same. I have applied for it, but it has not yet been received. So, Lordship,
So how much time you reach that?
allow me 2 weeks time.
taking time in 2 months
I am.
मिलो नहीं
It, but
2/12/2024
yes, my lord, I understand, my lord.
have you applied
Yes, sir. I have applied through the local lawyer. Yesterday I contacted him. He said
so
that
when
it
did
has
you
not
apply
No, no, whole thing ଜିନିଷ ହଉଛି କଣ କି ଯଦି ଆପଣ ଏତେ ସମୟ ଲାଗୁଛି ସାର୍ଟିଫାଇଡ କପି ଦବାକୁ ତାହେଲେ ଆମେ ଜୁଡିସିଆରୀରେ ଆମେ ସାଇଡରେ ଆମେ ଦେଖିବାକୁ ପଡିବ ଯେ କଣ ପାଇଁ ଡିଲେ କରୁଛନ୍ତି ଯେ
ସିଏ actually କଣ ହଉଛି ସିଏ ତାକୁ କହୁଛନ୍ତି ଫାଇଲ ଏଟା ବୌଦ୍ଧର actually case ସିଏ କହୁଛନ୍ତି record was sent to ଫୁଲବାଣୀ so
no, whatever it is procedure has to be followed it will come ସେ କେବେ apply କରିଛନ୍ତି ବୁଝିକି କୁହନ୍ତୁ
ହଁ
may not have applied also
no, I
2 ମାସ ଧରିକି ଗୋଟେ ସାର୍ଟିଫାଇଡ କପି ଅଫ ଦି ପ୍ଲେଣ୍ଟ ଆଉ ଇଏର କେତେ ସମୟ ଲାଗିବା କଥା
you all level to ask for time.
no, but what is the
That is
position
the
is
reality. ତାଙ୍କୁ ପଚାରି କହିବି
if there is any problem we will pass an order
ହଁ
ଆଜି
as ନାହିଁ ଆପଣ
ନାଇଁ
ବୁଝିକି କୁହନ୍ତୁ
ଆପଣ କହିବେ ନା
ମୁଁ କପି ମାଗିକିରି ଦେବି
ହଁ, ହଁ।
ଆସୁ 2 weeks ଭିତରେ ସେ ମୁଁ ତମ ଲାଷ୍ଟ ଟାଇମ
Alright.
କାଲି କହିଥିଲି
the learning council for the petitioner submitted that for the
copy has been applied for
for the order dated to 12/2024 the petitioners already applied for the copy of the plaint and
decree
passed in so and so
appeal memo and
also the appeal memo in so and so and for the time will be granted to obtain the same put of this matter. They don't put a piece of stuff for it, but they will go to that's the rule. 7 8 and what about yes minutes 8/4/2025
That's it, keeping it to 8.
8
And
Item 2.
yes password
Item 3. Item 4.
no, here's my job. I'm challenging the so much revision order passed by the UDM matter and dated
you have
29
supplied the consolidated petition of it you are challenging the order dated, you come to the order dated 22/1/2025, passed by this court, and you are challenging the order dated 29/4/1999, which was passed by the ADM Khurda in revision case number 57 of 1998. So we asked you on that day that why in 99 order is challenged in the year 2024.
Right.
And what are the averments taken in the writ petition to explain the delay on the part of the petitioners to challenge the same.
Right.
So for that you have filed that amendment petition, and that amendment has been allowed, and you have incorporated it and in the consolidated writ petition. Let us see that what are your averments explaining the delay.
Right. That is in my base writ application 6, paragraph 12. Can you please?
Yes.
The petitioner has purchased the suit land from original leased landowner through RSD number 3303 dated 13/9/1994. After purchase, the petitioner is in possession over the said suit land. After 3 years, that means after 3 years of purchase, the ADM initiated a suo motu revision case filed number 57 of 98 for cancelling the WLL case 179 of 72 without impleading petitioner as a party. The ADM decided the said revision case behind the back of the petitioner. So when the petitioner was not party in the said revision case and no notice was issued to the petitioner in respect of the said revision case, so it is not possible for the petitioner to know about the said revision case and cancellation of WL case. During high settlement operation, though the pacha in respect of suit land was prepared in favor of the petitioner, but subsequently it was cancelled. Final order was published in favor of the government. After knowing about such wrong recording, the petitioner preferred a revision case, right? Revision case number 68 of 2022 under section 15B of Orissa Survey Settlement.
Let us see that impugned order.
That is annexure 3, my lord.
Page 24.
Page 22. Right. With Lordship's permission, that have mentioned in second paragraph, my lord. In the impugned order, notice has been duly served.
So how do you say that it has not been served?
My lord, my lord, notice was duly served upon the my vendor, my lord, not upon.
How can we know?
My lord, thereafter they have mentioned. Notice was duly served. Opposite party is absent. Peruse the LCR of case number 179 of 72 and field inquiry report of the officer. The inquiry report reveals that opposite party has sold the lease land, which at present has not been demarcated and is lying fallow. So they have mentioned the opposite party sold the land, my lord.
So what is the terms and condition of that lease?
My lord, that
Can it be transferred to by way of this land can be given to you, and if so, under what are the terms and conditions?
my lord, that lease was granted in favor of my vendor on the basis of Javan lease, my lord.
Yes.
That is that Javan lease order is annexure 1, page 12, my lord.
Okay. Annexure 1.
My lord, annexure 1, page 12.
Which is the order?
My lord, the Javan is Golek Bihari Samantray, my vendor, my lord. Son of Gokulananda Samantray of village Sisho has applied for lease of land in Mauja, Simili Patna for plot number 67 under Khata number 237 with an area of 5 acres. Issue is there inviting public objection, if any, by PDC at Satostari. Asks the RI Chandaka to inquire the report by the date fixed. Thereafter, after local inquiry, RI Chandaka has recommended for sanction of lease out of plot number 67 under Khata number 230 7 Onavadi of Mauja Similipatna verified the resumption proceeding as and found that plot number 67 with an area 35 decimil is kept reserved for Joan. Thereafter, inviting public objection was duly published, but no objection received during the stipulated period. The applicant has been declared eligible for concession as per Home Department Resolution number 1943 dated 26/4/77. Therefore, an area 5 acre out of plot number 67 under Khata number 237 of Mauja, Similipatna is sanctioned in favor of Sri Golok.
Now, this is the order, but where is that lease deed? Because that would show the terms and conditions. It is granted under the Government Grants Act, this Jawan lease. So you cannot just transfer it unless there is a provision there, and in case that also you have to take permission of the authority. That was granted to you because you are a Jawan. Now, if you utilize for that you said to XYZ and government land, and there must be something in that lease deed that how if you intend to transfer, let us say for some financial difficulty, you want to transfer it. So there must be something in that you have to take permission from the authority.
And the ensuing order, para 6 also mentioned that the lease is granted for agricultural purpose, but the land is not the cultivation.
No, but was there any bar in the lease for disposing,
That can be done
alienating?
only. It can be if we look into that lease deed, then we can. This is the order passed in that WL case. From that we cannot know that what were the terms and conditions. The detail would be there in that lease deed itself. Because in most of the cases like that, the condition has been stipulated that you cannot transfer it to anyone, and if you intend to transfer it for some specific reasons, then the permission has to be taken from the government, and they will verify it that whether the reason which you are ascribing with it, that is genuine or not. All those things can be, then it can be done. Otherwise, without permission, you cannot transfer. That is there. Case laws are also there on that. The one grant lease.
There must be a standard format also for grant of the lease.
That each case has to depend. So have you got that?
No, I have not got that lease statement.
That goes to the root of the matter. You say now you are challenging on the ground that principle of natural justice has not been followed, though the authority was aware that this has been transferred to me by way of a registered sale deed, but still then opportunity has not been given to me to have my say. But question is that whether he could have transferred to you or not. That registered sale deed, that is the crux of the matter, and that can be adjudicated only when we see that deed itself. So,
with Lordship's permission,
yes,
I took time for
you take time and obtain that
lease deed.
Okay, from the person. I hope that while during the execution of this registered sale deed, your client must have also got that copy of that, because that is the root of the matter. ଏଥିରେ ମଧ୍ୟ ଲେଖା ହେଇଥିବ ଏଇଟା ଗୋଟେ ଜବାନ ଲିଜ୍ ବୋଲି ଆପଣଙ୍କ ଯୋଉ ରେଜିଷ୍ଟର୍ଡ ସେଲ୍ ଡିଡ୍ ଏଥିରେ କିଛି ଲେଖା ହେଇନି ଯେ ଏଇଟା ସରକାର ଏଇଟା ଦେଇଥିଲେ
Can you also bring the records of WL lease case number, Mr. Naik? Get that records of the WL lease case number 179 of 1977. Tadar bhi thibo.
ଗୋଲକ ବିହାରୀ କେମିତି ଏ ଜମିଟା ପାଇଲେ ଏ ବିଷୟରେ ଯୋଉ ବିକ୍ରୟ କବଲାରେ କିଛି ଲେଖା ହେଇନି, ସେମିତି ଲେଖିଲେ
ଯେମିତି ତଳ ଆଡକୁ ଲେଖା ହେଇଥାଏ ଦେଖିଲେ
এটা তো প্রাইভেট
ଏମିତି ପାଇଲେ ଆଉ ସେଇ ହିସାବରେ ଏନ୍ଜୟ କରୁଛନ୍ତି। ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଟା ପ୍ରାୟ ଲେଖା ହୁଏ।
ନାଇଁ ଏଇଥିରେ ଶୀର୍ଷ ତଫସିଲ ନିଜ ନାମରେ ରେକର୍ଡ ଦରଜ ଥାଏ
না
ଭୁବନେଶ୍ୱର
না না এটা
ଲେଖିଥାନ୍ତି ପରମିଶନ ନିଆହେଇଛି ଏଇ ହିସାବରେ ସରକାରଠୁ ପାଇଥିଲେ ପ୍ରାୟ ନଥାଏ ଲାଷ୍ଟ ଆଡକୁ।
So two things, you get the lease deed and the land and council for the state also. You get that WL, okay, lease case record 179 of 1977. Lekhundu, peruse the grounds taken in the consolidated writ petition relating to the explanation for inordinate delay in approaching this court in 2024 by the petitioner challenging the order dated 29/4/1999 by Annexure 3 passed by ADM Khurda in revision case number 57 of 1990. Stop. The vendor of the petitioner, namely Golok Bihari Samantray, bought the land in question by way of Joan lease, and the copy of the lease deed has not been annexed to the writ petition, though the order passed in WL lease case number 179 of 1977 has been annexed to the writ petition as Annexure 1. In order to appreciate the contention raised by the Land Council for the parties, we ask the Land Council for the petitioner to produce the lease deed in favor of Golok Bihari Samantray. Stop. The Land Council for the state shall also produce the records of WL lease case number 179 of 1977 from Tahsildar Bhubaneswar. Put up this matter. Kebe rakhiwa upon seta anibe siye seta anibe.
2 weeks.
So let it be on 8th of April 2025. List this matter on 8th April 2025. Free copy of the order be handed over to the Land Council for the state. So this is to come along with your connected matters. Same time. It a faster related.
Item 5.
In this case, the petitioner challenged the order of the assistant settlement officer recording the land of the petitioner under government customers. Facts are like this one. 1976 lease
What is that order?
Annexure Miller 7
Annexure 7.
page 30.
So have you gone through the order passed by the Honorable Supreme Court in that Narottam Rath case?
Yes, ma'am.
So they have stated that since there are alternative remedy available, so the court has to, in individual cases, the court has to see whether the petitioner has resorted to the alternative remedy or not. the alternative remedy are there in the Service and Settlement Act, like you have to file the approach which forum categorically stated. There is a provision under section 12, देखिए था
15B and
15B is there,
and
and,
55 also.
twelve-
That the
survey and settlement.
15B.
15B is there.
Appeal lies first against the order of the Assistant Settlement Officer under section 12A.
Now the quota has been issued, so
If final publication has been made, then the
revision.
revision lies.
Final
Revision lies.
publication has been made.
That is exactly. So the revision, if final publication, then 15 B says revision before the Board of Review. So that you have not taken recourse to. So you have to take recourse to. And that period is on an application made within 1 year from the date of final publication under section 12B.
That order, Annexure 7 was passed my lord behind my back, man.
No, it's
I
all
was
right. That point you can also raise before the revisional authority. So because of all those cases were earlier disposed of, but now in view of the decision and when the categorical hint
Yes,
has
yes,
been
ma'am.
given that they have to approach the
I
alternative.
pray my lord, let the matter be kept pending till disposal of that batch cases.
That is the order was passed on 2013. Now in the year 2025.
No, without behind my back, no notice was served on me.
No, that ground can be taken, Mr. Mr. Mahanti. That ground can be taken that all whatever you have stated that behind your back you are not aware. So this limitation when it came to your knowledge. Number two, that you have approached this court and
Following the
we
decision,
will give pass the order that you have not approached in view of the Narottam Roth case, then you can get that clue there or the points that you can take a ground to condone the delay in preferring the revision petition.
I
What do you
pray
say?
let the matter may be kept pending till the other cases are decided by the
There are different dates.
ଥିଲା
Different
ସାମନ୍ତରାୟଙ୍କ
dates
ଗୋଟେ
ଅଛି।
ମ୍ୟାଟର ଡେଟ୍ କୁ ଥିଲା
different dates ଅଛି। अब that
ଡିଫରେଣ୍ଟ
matter
ଡିଫରେଣ୍ଟ ହେଲେ ଦିଟା ଡେଟ୍ କୁହନ୍ତୁ
Obviously ଗୋଟେ ଦିନରେ ରହିପାରିବନି କାରଣ ସେଗୁଡାକ ସବୁ
ବହୁତ ହି ଅଛି।
ଅଲଗା ଅଲଗା
ଅଲଗା
ପୋଜିସନ
ଅଲଗା
ଦିଟା ଡେଟ୍ କୁହନ୍ତୁ
କାରଣ ସବୁର ଫ୍ୟାକ୍ଟ ସମାନ ନୁହେଁ ତ
ନା,
ସେଇଥିପାଇଁ ତ
different
ଅନୁଭବ
ସବୁ
ସୁପ୍ରିମ କୋର୍ଟ କହିଲେ ଯେ ଇଣ୍ଡିଭିଜୁଆଲ କେସ୍ ଗୁଡାକ କନସିଡର କରି ପଡିବ।
ଆରେ କେବେକୁ ଅଛି କୁହନ୍ତୁ ଦିଟା ଅଲଗା ଡେଟ୍ ହେଇଥିଲା ମନେ ଅଛି ସାତ ସାତ କଥାକୁ ତାପରେ ଦେଖିବା
The petitioner challenged petitioner Niranjan Nanda has filed this petition challenging the order passed by the was passed ASO Kutiyara.
ଭୁବନେଶ୍ୱର
ଦେଖିନାହାନ୍ତି ଆପଣଙ୍କର ପ୍ରେୟାରରେ କିଏ ପାସ୍ କରିଛି ଅର୍ଡରଟା Annexure 7 ଟା କିଏ ପାସ୍ କଲା
ASO rental colony
Assistant Settlement Officer
Officer.
Rental Colony
Bhubaneswar.
Bhubaneswar in rent case number 10226 of 2013. এবং ସେ ଲେଖିଛନ୍ତି ମଧ୍ୟ the affected party have scope to appeal before
Right.
the appellate authority. ekatha mi lectured to prove the
genuineness of their claim.
Um, so
Final ROR has been published.
Mr. Mahanti, London Counsel for the petitioner, submits that this order, it was passed on 8/7/2013. Next
13, my lord. 15/7/2013.
और गोटे सिग्नेचर अच्छी सिग्नेचर गोटे डेट अच्छी अच्छा 15/7/2013 है ना पास बाय असिस्टेंट सेटलमेंट ऑफिसर रेंटल कॉलोनी सुवांशु Mr. Mahanti Land Council submits that this order has been passed behind the back of the petitioner and though it is mentioned in the impugned order that the affected parties have scope to appeal before the appellate authority to prove the genuineness of the claims. However, since final publication of ROR has already been made, the petitioner can now approach the revisional authority in view of section 15 bracket small b of the Odisha Survey and Settlement Act 1958. He submits that similar matters are sub judice before this court, and the matter may be heard in the after 2 weeks कर दें है List this matter in the कितने अच्छे था साथ है list this matter will be commencing from 7 4 or लिख दें on लिख दें 7/4/2025.
Item 6.
Mr. Vera,
My lord.
the records of WA case that is there. Let us see that order again once again. No. 4/3. Have you got that order dated 4/3/25 weekly? 4/3/2025 order टा टी पढ़ंतु.
Your lord.
पढ़ंतु माने अपन चुपचाप नहीं अपन पढ़ंतु.
Yes.
Yes, read it out.
The matter is taken up through hybrid arrangement. The review petition has been filed to recall or review the judgment and order dated 13/1/2025 passed by the Revisional in WA number 77 of 24. It appears that the writ appeal was filed challenging the judgment and order dated 31st October 2023 passed by the learned single judge of this court in WA petition number 165 of 2017, whereby the learned single judge has allowed the writ petition filed by the petitioner by setting aside the order rejecting the petitioner's application for appointment under the Rehabilitation Assistance Scheme. In the writ appeal, after discussing the factual scenario as also the discussion of Honorable Supreme Court, this court was of the view that issuance of a direction by the learned single judge for considering the case of the petitioner for appointment on compassionate appointment more than 17 years after the death of the government servant defeats the very purpose of this scheme for appointment on compassionate ground. Learned counsel for the petitioner referring to the death chart submitted that the father of the petitioner died on 28/9/2006 when she was a minor, and after attending the majority, she submitted the application for the executive engineer Subarnarekha Irrigation Division Project, Division number 2, Deuli, Mariband, for engaging her in the post of peon under the Rehabilitation Assistance Scheme, along with all necessary documents on 6/7/2013. Prior to that, on 3/7/2013, the mother of the petitioner had sworn an affidavit requesting to appoint the petitioner, who was her only daughter, under the Rehabilitation Assistance Scheme. It appears that during the hearing of the writ appeal on 21/8/2024, the matter was adjourned on the prayer of the learned counsel for the petitioner for the obtaining instruction and to file an affidavit. It is the contention of the learned counsel for the petitioner that the petitioner filed an affidavit in court, but the same has not been taken into consideration while passing the judgment in the writ appeal. Learned counsel for the petitioner draws the attention of this court to the legal hair certificate under Annex 3 series at page 25, issued by the Tahsildar Baripada, which also shows that the petitioner is the only child of the deceased government servant, namely Parameswara Machi. He submitted that a copy of this affidavit had been filed in the writ petition. The affidavit, which is stated to have been filed by the learned counsel for the petitioner in the writ appeal, is not available in the digital record of the writ appeal. The physical record is of the writ appeal number 777 of 2024 be produced on the next day. Let the learned counsel for the petition file the copy of the affidavit stated to have been filed in the writ appeal with a memo. I have also filed the same memo. Filed on 5/3/2025.
When had you filed it?
5/3/2025.
Affidavit টা?
Yes, in this regard, writ
No. The writ appeal টা কেবে file করছিস?
appeal you already said.
You had said you had filed it. So could you just second the physical record টা we have called for?
23/8/2024.
Just put. Court এ file করলে that is the problem. Nothing is doing. Okay. Dated, affidavit dated?
23/8/2024.
ठीक है, noting का है नहीं और court is going to do something, but it is there in the record. कौन बोला? କାହାକୁ file କରିଛି? 13? ହଁ ଏଇଟା ପୁରା ମନେ ଅଛି ତ କୁହା ହେଇଥିଲା ଦବା ପାଇଁ। ସେଠି କୋଉଠି ଗୋଟେ ଗେଞ୍ଜି ଦେଇଛନ୍ତି, noting ହେଇନି କି note ବି ହେଇନି ତ ସେଇଟା problem ଆଉ। noting କରିନି ଖାଲି ଦେଇ ଦେଇଛନ୍ତି record ରେ, ସେଇ agreement ଲେଖିଲା ବେଳେ ବି ଦେଖାଏନି। notice କର ଆଉ ଇଏ କର। There is a record. So there is no nothing, but it is there in the record. Stamp भी नहीं, किसी नहीं, but it is there in the record.
As per the order dated 4/3/2025, the reports of WA number 777 of 2024 was produced by the registry, and we find
Noting है।
that
Order टा भी अच्छे से है, no problem.
an affidavit has been filed by Parvati Soren alias Parvati Majhi,
dated for them.
affidavit dated for 23/2024 has been filed by Parvati Soren alias Parvati Majhi, the mother of the petitioner. And the order dated 28/8/2024 also reflects about the filing of such affidavit. It is the contention of the land counsel for the petitioner that this affidavit has its own significance in the adjudication of the writ appeal, but the same has not been taken into consideration. If you notice on the question of admission, indicating therein that the matters have been disposed of at the stage of admission, land counsel for the state accept notice on behalf of all the opposite parties. And extra copies of the original petition is and the land counsel for the state and the district police were out in their meeting. আচ্ছা এইটা যেটা কয়েকবার যে আপনাকে ফাইল করে সেটা করে না নাই
ଆଜ୍ଞା 5/3 ରେ କରିଛି
সেটা কোটি সেটা কাହିଁ ରେକର୍ଡ ଅଛି ଦେଖିଲେ ସେ ଗୋଟେ 5/3 କଣ କରୁଛନ୍ତି ପୁଣି ନହେଲେ କନଫ୍ୟୁଜିଂ ହବ
ଆଜ୍ଞା ଏଇଟା ରିସିପ୍ଟ
ସିଆଡେ କହିଥିଲା ଫାଇଲ କରିବା ପାଇଁ ଦେଖିଦବା ରେକର୍ଡ ଅଛି କି ନାହିଁ ପ୍ରୋବ୍ଲେମ ଯୋଉ ଏଇଠି ଫାଇଲ କରୁଛନ୍ତି ମିସ୍ ହେଇଗଲେ ପଳଉଛି
ରିସିପ୍ଟ ଅଛି
ଦେଖିଲେ
ଏଟା ସି ଫାର୍ଷ୍ଟ
ସ୍କାନିଂ ହେଇନି
ହଁ ସ୍କାନିଂ ନହେଲେ ସ୍କାନିଂ କରେଇଦବା ଅଛି ତ
ଆଚ୍ଛା it further appears that ଲେଖିଦେବା out line that the said affidavit filed by Kitamani Soren alias Majhi dated 23/8/2024 copy of the has also been filed by the Land Council for the petitioner with a memo dated 5/3/2020. And the same is available on record. Yes.
Item 7.
This is a case regarding the National Highway extension on 2002 acquisition of 2002. The award has been passed on 12/8/2021 by Annexure 1. Till date, they have not, but the Annexure 2 is the covered matter 30%.
You come to the order dated 28/8/2025. Have you got that order? Mark out the 28/1/2025. Please place it.
The read petition has been filed by the petitioner K. Sujata Acharya, inter alia with a prayer to direct the opposite parties, more particularly opposite party number 1 and 3, as to why the petitioner shall not be entitled to get the compensation for construction trees are well over the acquired land and 30% solar system plus 12% interest in total from the date of acquisition along with the compensation 5 lakhs for the mental agony and suffering of the petitioners and for further direction to the opposite parties to pay the compensation for building well and trees, etc. 30% solar system and 12% interest in total from the date of acquisition plus for mental agony and suffering or 15% interest of the total compensation amount instead of 12%. The Lawrence Council for the petitioner placed judgment and order dated 12/8/2021 passed by the Lawrence District Judge Contempt Barampur in SPJC number 3 of 2018, in which the reference under section 3H4 of National Highway Act 1956 made by the Tahsildar competent authority Konisi Ganjam was answered, and it was disposed of with a direction to the competent authority to disburse the value of land to the deities to Inspector of Endowment and the value of structure to respondent number 2 petitioner within a period of 2 months from the date of receipt of that order. The learned counsel for the petitioner submits that in spite of such order being passed since more than 3.5 years, the petitioner is yet to receive the value of structure as per the aforesaid judgment, that is SPJC number 3 of 2018. Mr. U.C. Mohanty, learned counsel appearing for National Highways Authority, submits that the petitioner has not included the National Highway Authority as a party who needs to make payment to the petitioner. Learned counsel for the petitioner seeks some time to file the interim application to include the National Highway Authority as an opposite party. Learned counsel for the National Highways Authority shall obtain instruction as to whether any money has been deposited with the opposite party number 2, land acquisition officer cum competent authority of National Highways Authority of Odisha, Chhatrapur, Ganjam, as per the order passed by the District Judge Ganjam, Barampur in SPJC number 3 of 2018. And if so, why disbursement of money has not been made to the petitioner as per the said order. A copy of the writ petition be served on the learned for the National Highways Authority in course of the day. The matter will be placed immediately after filing of the interim
So
application.
who is appearing for the opposite party?
Last date
SK Divedi last
Last.
743 date. Because body is still in it.
Because in the cost prices there was that kind of, so I started looking for it and found it. And last day, none of those councils were there because of this years. Including the learned council for the petitioner.
The memo has been filed by Mr. Dinesh Chandra Mohanty. Very stated that since the creator of the engagements has been withdrawn, his name will be repeated for the opposite party number 2. So it appears that Santosh Kumar Vigilance has already filed power for opposite party number on 25 to 2025. Take the name of Mr. Umesh Chandra, Mr. Divedi is not present today. The name of Mr. Umesh Chandra Mohanty and his associate, some of the reflected in the policy transport. That will be listed on 18th of March 2025, indicating the name of Mr. Santosh Kumar Dwivedi only on the cause list as the counsel for the opposite party number 4.
496 bookmark.
The bookmarks be carried out in the
Digital.
by the digital
In the digital record.
in the digital record. Stop. Mr. Dwivedi shall obtain instruction in terms of the order dated 28/1/2025.
Copy of the order ଗୋଟେ ତାଙ୍କୁ ନିଆ ହଉ ନ ଜାଣି ପାରିବେନି
Hmm.
କପି ଅଫ ଦ ଅର୍ଡର ତାଙ୍କୁ ପାଇବ ରେଜିଷ୍ଟ୍ରି ଗୋଟେ ଦେଇଦବ
Let a copy of the order
ଇଏ ବି
dated.
ଦେଇଦେବେ
Hmm?
ମ୍ୟାଡାମ ବି ଦେଇଦେବେ
ଆପଣ ଗୋଟେ କପି ଦେଇ ଦଉନାହାନ୍ତି ମିଷ୍ଟର ଦ୍ୱିବେଦୀଙ୍କୁ ହଁ let a copy of the order dated 28/1/2025 ଗୁଡା ସବୁ ଆପଣଙ୍କ ପାଖରେ ଅଛି ତ
ଡାଉନଲୋଡ ହେଇକି ବାହାରିଯିବ
Download ହେଇକି ବାହାରିଯିବ 28/1/2025 then 4/3/2025
along with the consolidated writ petition
along with the along with 2 days order and the consolidated writ petition be handed over by the land council for the petitioner to Mr. S.K. Dwivedi, land council for the opposite
ସେଠି
party.
ଚେକ୍ କରିଦିଅନ୍ତୁ ତାଙ୍କ ଫୋନ ନମ୍ବର ଟା ଥିବ ୱକାଲତନାମାରେ ଚେକ୍ କରିଦିଅନ୍ତୁ
You have got that number ଅଛି ଆପଣ ଲେଖିଲେ
ପାଇଲେ
uploading 99 ଆପଣ ଗୋଟେ କାଗଜରେ ଟିପି ଦେଇ 99 389 976 49. It is the mobile number of Santosh Kumar Dwivedi. He is the counsel for the opposite party number 4. ତେଣୁ ତାଙ୍କୁ ଆପଣଙ୍କର consolidated writ petition ର କପି ଏବଂ ଏଇ ତିନିଟା ଅର୍ଡର ଦେଇଦେଲେ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ and let the matter come.
ବୁଝିଦେବେ ଯେ ତାଙ୍କର ନଥିବ ଦେଇଦେବେ ନା ଯଦି ଅଲରେଡି ପାଇଯାଇଥିବେ ଖାଲି ଲାଷ୍ଟ ଅର୍ଡର ଟା ଦେଇଦେବେ ଆସୁ 2 weeks ନାଇଁ
ଆଜି 8 ତାରିଖ ଦେବ
ହଁ ଠିକ ଅଛି
8 April 2020.
ଯେତେ ଜଲ୍ଦି ହବ ଦେଇଦିଅନ୍ତୁ
18/3
8/4/2025 ରେ ଆସିବ because he has to take instruction in the matter.
ଗୋଟେ ବି ଆଗରୁ
present last
ହଉ ଠିକ ଅଛି ରହନ୍ତୁ।
अच्छा ठीक है 25
ପଚିଶ ହବ 2 ବି ହବ 2 ଆଚ୍ଛା 2ଟା ଇଏ ହଉଛି ହଁ 2 ତାରିଖରେ ହବ ମାନେ ଫାର୍ଷ୍ଟ ଟା ଛୁଟି ଅଛି 2 ବି ହବ 3 ସପ୍ତାହ ହେଇଯିବ 2 ସପ୍ତାହ ଦେଇଦିଅନ୍ତୁ 2 ସପ୍ତାହ
2/4/2025. All right.
Item 8.
So each matter for next week. On the last occasion, I had taken time to verify which provision of Government Grants Act.
ଯବାନ ଲିଜ ନାଇଁ
Government
ଆମେ ଏଇଟା
grants
କେବେକୁ ରଖିଲୁ ସେ ନକରୁ ସେ ଯବାନ ଲିଜ
ଆଜି ଗୋଟେ ଥିଲା ଯୋଉ ଜବାନ ଲିଜର
କେବେ ରଖିଲୁ
Item 5.
କେବେକୁ ରହିଲା 5 ଟା 5 ନା 4 ଆଚ୍ଛା 5 ନା 5 ଟା ଯବାନ ଲିଜ ନୁହଁ
4.
ଆଇ ଥିଙ୍କ ଆଇଟମ 4
8/4 ठीक है
ଆଚ୍ଛା
लिख दो Mr. Lenka Land Council appearing for the petitioner is for an adjournment. Raise this matter on 8/4/2025. Yes.
Item 9.
Humble petition approved before the Honorable Court for direction to the authority opposite to number 3. Joint officer from land acquisition of LA collector for enacting of benchmark violation as per Annex 4 representation dated 22/10/2024. Under section RA right to fair compensation Transparency Land Acquisition Rehabilitation Resettlement Act 2013. The section 64.
No. Where is your application? Under section 64. Have you filed before the authority, the collector?
No.
Already I have given the document.
Yellow packet.
ଆପଣଙ୍କର 64 ରେ ପାୱାର ଅଛି ଯେ ଏଇଟା ରେଫର କରିବେ ଅଥରିଟି କୁ ଅର୍ଥାତ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ କୁ which consider about the enhancement factors. You are claiming higher compensation. तो यो रिप्रेजेंटेशन रे कौन काम हो रिप्रेजेंटेशन पुनी देइचंती काहाकू देइचंती
Ele collector.
Yellow packet.
You not sir come ele
no
Collector.
64 you देखिए
64 the collector.
64 is meant for the collector and collector is to refer the matter to the district judge. He is the authority.
Under section 51 of the RFCTL Act. Right to
Any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of the authority.
under section 51, establishment of land acquisition rehabilitation and resettlement authority. Appropriate government shall, for purpose of providing speedy disposal of the dispute relating to the land acquisition, compensation, rehabilitation, resettlement, established by notification one or more authority to be taken as the land acquisition, rehabilitation, resettlement authority to exercise jurisdiction powers and authority concerned on it or is by or under this act. Appropriate governments are also specified in the notification refer to subsection 1 the area within which the authority may exercise jurisdiction for entertaining and deciding the reference made to it under section 64 or application made by applicant under second proviso to subsection 1 of section 64.
So see जो authority किए होबो ता सेटा तो already he is to be a district judge.
LAR collector, LAR land acquisition, rehabilitation, resettlement authority.
The composition of authority देखो 52 रे. The authority shall consist of one person to be appointed by the sworn so by the appropriate government. है Notwithstanding anything contained in the appropriate government may authorize the presiding officer of one authority to discharge also, and the presiding officer must be a district judge. District judge पाखु एगुड़ाक सब रेफर हुए कलेक्टर रेफर करती तो आपण कलेक्टर को पाखरे ही 64 एप्लीकेशन दबा कथा
Different. He is a misconception that the land acquisition officer can collector the special that is the collector. Collector is the district magistrate.
Collector means the district magistrate from collector.
And 64 proviso is there. If the collector fails to refer, then directly
you see the collector definition is there in section 3G. 3G re collector mane hochi collector of the revenue district. Includes so and so. So it is not that
LA collector.
So this representation would not do. You withdraw this writ petition, file appropriate petition before the collector, and the period also prescribed there that within which period you are to make such application. Of course, he has got power to condone the
1 year delay.
1 year within a period of 1 year. So may entertain the after the expiry of the said period within a 4 hours. So maximum time that has been given is 1 year. Otherwise,
already
that application would not do. You withdraw it.
Annex 3.
Look, this writ petition has been filed with a prayer for a direction
I prefer direction to LAR authority. For
to such and
consideration.
such. The land counsel for the prayer like this. Land counsel for the petitioner submits that the representation has been made before zone officer and LA collector SIP Lakshmi Posi Baripada Marvanj. However, in view of section 64 of So Act 2013, Land Council for the petitioner seeks permission to withdraw this petition, to approve which the appropriate authority for making reference to the authority. Accordingly, the writ petition is disposed of.
Item 10.
Next one is the ROR. The land stand recorded in the name of the petitioner and which they lent to the government. Now over the said land, the revenue authorities have already constructed a road. So he approached this honorable court in the earlier read petition, that is 21699 of 2024. The Lords will get the order at page 17. This honorable court directed the petitioner to make a representation before the Tahsildar Derabis.
And you submitted it.
I have submitted the representation.
What happened?
And person annexure 4.
Yes.
By representation, pursuant to that, the Tahsildar directed the local RI to cause an inquiry and submit the report.
Yeah.
The report is annexure 5.
Yes.
By virtue of that report disclosed that a Hoka road has been constructed over my land. Thereafter, the Tahsildar has not, annexure 5, my lord, page 21.
Page 21. कौन है कड़ा दिखाओ मौजा गुआल सिंह को जाई
ସରଜମିନ ତଦନ୍ତ କରିବାରୁ ଜଣାଗଲା ଯେ ମୌଜା ଗୁଆଲ ସିଂ ଖାତା ନମ୍ବର 1362 ପ୍ଲଟ ନମ୍ବର 4167 ରକବା 1075 ପ୍ରଜା ମୀର ମହମ୍ମଦ ହସିମୁଲ୍ଲା ପିତା ମୀର ମହମ୍ମଦ ଜାତି ମୁସଲମାନ ବଡହାଟଙ୍କ ନାମେ ଖତିଆନ ପ୍ରଚାର ହୋଇଅଛି। ସରଜମିନ ତଦନ୍ତ ବେଳେ ଦେଖାଗଲା ଯେ ଏହି ପ୍ଲଟ ଉପରେ ଢଳେଇ ରାସ୍ତା ନିର୍ମାଣ ହୋଇଅଛି।
So now
the Tahsildar, thereafter Tahsildar has not taken any decision. After getting the report, the Tahsildar is sat over the matter.
The direction was only to dispose of the representation that he has done. So
the representation has not been disposed of. Only he sought for an inquiry. The inquiry report has been submitted. Thereafter, no.
Yes, Mr. Mahanti. Now, in view of this inquiry report, it is clear that the public road has been constructed over the land of the petitioner, and he has not been paid compensation.
Instruction.
They will take instruction. This writ petition has been filed by the petitioner Mir Muhammad Hasimullah. With a prayer for sponsor execution. The London Council for the petitioner submitted that when the petitioner earlier approached this court in WPC number 21699 2024, the same was disposed of by order dated 13/9/2024, and the opposite party number 3, Tahsildar Deravis, was directed to take a lawful decision on the representation filed by the petitioner within a period of 3 months from the date of receipt of the representation. The Land Council further submits that in pursuance of such order, the petitioner submitted the representation on 23/9/2024 before the opposite party number 3, who ordered the revenue inspector Wal Singh Circle to cause an inquiry, and the inquiry report dated 12/11/2024 has been submitted by the revenue inspector, which should show that the a public road has been constructed over the land of the petitioner. Land Council submits that till date the petitioner has not received any compensation in that respect. Land Council for the state seeks some time to obtain instruction in the matter of this matter on every phone.
3 weeks time.
3 weeks time. So let it be on 8th of April 2025.
Okay.
Item 11.
Item 11, Annexure 6 is pending, opposite party number 2.
What is that Annexure 6?
Annexure 6 is for enhancement of the compensation amount.
Under what
Under
provision?
64.
64.
Land actions at right to fair compensation transfer land action relocation settlement act 2013.
Zone officer, এটা collector को दवा रखा आपको?
Collector come zone officer.
No.
Collector appointed as a zone officer come collector.
Collector is not appointed as zone officer.
He is
The collector.
Closely kindly give a liberty petitioner file a fresh representation for give a procedure.
No
that you-
representation, application.
application is to be made. ଆପଣ enhancement claim କରୁଛନ୍ତି ନା,
ଆଜ୍ଞା।
ତ ଆପଣ reason ଦେବେ ଯେ side ର
ଆଜ୍ଞା।
ଜମିର ମୂଲ୍ୟ ଏଇଆ ଏଇ ସବୁ ଜିନିଷ ଲେଖିକି
Potentially it is very high and so that's
supporting
why
documents
supporting
of private.
documents
Again.
also. So
Again.
that application has to be referred to the planning district judge. Who
Next
is
on
called
the presiding officer in
Lara
Lara Court.
Acha.
Again, ଏବେ ନୂଆ ହେଇଛି 2014 ରେ ସେଇଠି
Alright.
refer.
So we are giving you permission to.
But land acquisition authority collector also refer.
ନା ନା ସେଟାକୁ ଆଡ୍ରେସଟା ଭୁଲ ହେଇଛି ଜୋନ୍ ଅଫିସର କମ୍ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ କଲେକ୍ଟର ଯୋଉ ଲେଖା ହେଇଛି ସେଟା କଲେକ୍ଟର କେବଳ ହବ କଲେକ୍ଟର ଇଜ ଡିପେଣ୍ଡ ଅନ୍
ନାଇଁ, ଖାଲି ଆଡ୍ରେସ ହବନି, କଲେକ୍ଟର କୁ ଦିଆ ବି ହବ।
ଗୋଟେ ଡିଟେଲ ରହିବ
Enter villager also give a representations for collector including land acquisition officer.
ରିପ୍ରେଜେଣ୍ଟେସନ ରେ ହବନି, ଯଦି ହେଇଯିବ then you withdraw this
ଆପଣଙ୍କର
and keep going.
individually ପ୍ରତ୍ୟେକ ଯାହାର ଜମି ଯାଇଛି
ଆଜ୍ଞା ଆଜ୍ଞା
ତ ସେମାନେ individually
ଆଜ୍ଞା।
ଫାଇଲ କରିବା କଥା, not that ଗାଁ ବାଲା ଇଏ କଲେ। ତ ଯାହାର ଯାଇଥିବ ସେ ଜମି
ପିଟିସନର ଅପସନରେ
award ହେଇଥିବ, ଯୋଉମାନେ claim କରୁଥିବେ
ଆଜ୍ଞା।
higher compensation ପାଇଁ
ଆଜ୍ଞା।
with reasons they are to prefer that file that application.
ଆଜ୍ଞା।
ହେଲା, it's not that in a general manner ଗାଁ ଲୋକ
ନାଇଁ, ଗାଁ ଲୋକ
representation ଦେଇଦେଲେ।
Enter ଯୋଉମାନଙ୍କର ଜମି ଯାଇଛି
ନାଇଁ ନାଇଁ, ଯଦି ତା ଦେହରେ ହେଇଗଲା ଭଲ
ଆଜ୍ଞା
କଥା,
ହେଇଯାଉଛି
but we cannot give a direction to the wrong authority to dispose of.
The
honorable court orders it and also
the petitioner, this petition has been filed by the petitioner Susmita Bindhani with a prayer for a direction to the opposite party to take necessary action regarding consideration of representation under Annexure 6 and to re-estimate the quantum of compensation amount as per government benchmark valuation and nearest vicinity stop. After arguing for some time, the Land Council for the petitioner seeks permission to withdraw this writ petition to file appropriate application before the appropriate authority. For taking the decision. Accordingly, the writ petition is disposed of as withdrawn.
up to item 15 my lord.
Up to item 16.
15.
15. All right. Yeah.
Item 16.
Yeah, Mr. Oja, Manoj Oja. Okay.
That's hard, Mr. Manoj.
Please, my lord, in this case, the petitioner has been awarded 20,60,400.
The extent is also the same. The representation at Annexure 5 is supposed to be in the format as per section 64 of the LA Act.
Same thing again.
Same thing. They have made an application only.
No application, but to the right authority or not?
Right authority. Form of a representation.
ଏମିତି ଲେଖିଲେ କେମିତି ହବ ଆପଣଙ୍କର?
Representation dispose of.
Because it is ultimately it has to go to the land district judge. ଏମିତି ଲେଖିଲେ କଣ ସେ ଆପଣ ଗୋଟେ authority ସେଠି ପୁଣି evidence adduce ହବ ସେ ଦେଖିବେ.
And more importantly, the representation is dated 31/1/2021. The writ application was filed on that day itself.
It's all right. But better you file, withdraw it and file it.
May one thing, my lord, with that observation, my lord may dispose of the matter so that collector will take appropriate action.
No. You have to file again that application in proper format. Because
No, shall we dispose of saying that no direction can be issued on basis of this representation? It is open. Or if you withdraw, we will note. It is up to you. We can pass both orders. Jota kahibe.
Withdraw, ma'am.
Withdraw.
the petition has been filed so and so. However, the land council for the petitioner seeks permission to withdraw the writ petition to file appropriate application in terms of section 64 of this one so before the opposite party number 2 according to the petition is disposed of the victim. Yes.
Item 17.
Item 17 to 19. Grant me some more time to comply with the order.
It a first time was she?
The second time. Astilar. Listed on 6/2/2020.
So it was first listed on 6/2/25. So almost a month has been passed in the meantime.
Can 10 days I'll take instruction as to what steps have been taken. Whole time I will finish up the area.
So let it come on 2nd April.
2nd.
The Land Council for the state seeks some more time to obtain instruction relating to the status of application under section 28 of the Land Acquisition Act 1894. List this matter on 2nd April 2025. Same order in the other two?
17 to 19.
17 to 19. 20. Olga Prakash?
No, 20 is different, sir. I mean 17 to 19.
17, 18.
And 19.
And 19.
19 I am not the council.
19 the order देखने वाले की
19 the more council.
2020. That's the order date is from 1990.
Who is there for the petitioner in item 19? Ms. Rai, you are there? The time. That also you got instruction, you want time?
I want time. 17 to 9, I had 6 more times.
Roy.
Agni Sikha Roy.
And 20 is your matter, Mr. Behra?
20 is time barred. 20 is time barred.
Time barred.
So my kindly see the page 17. That was the last order in the contempt application. That was dated 24/2023.
Just a minute.
Page 17.
It appears that the order dated so and so passed by this court has not yet been complied with. Let the opposite party comply the same, if not already complied in the meantime within a period of 3 months from the date of communication of this one. Then what happened?
Thereafter, you have given an representation on 39/2024, which is on page 18. After 1 year. And thereafter,
No, this is item what item?
Item 20. Contempt application 532 of 20.
Just
Okay.
20 order of the passage and next year
9/12.
नहीं
9/12 रे order pass ହେଇଥିଲା ସେଟା ତ
नहीं
First order
item
is
number 20 तो contempt application number
1912. First order is 1912.
हाँ
19/12/2022. Thereafter, the contempt application was filed in 2023. The contempt application disposed of by order date 20th April 2023. The representation was made on 30/9/2024, which was page 18. And the present contempt application filed on 28/1/2025.
So why are you saying it is time barred?
After 1 year.
No, no,
1 year kodiyala.
the order
The
has been
first order,
passed.
the second order, the contempt application.
The order has been passed on 19/12/2022.
Yes, sir.
And you are supposed to comply the same. And in
Within a
the
month.
in the earlier order,
Yes, sir.
there was a direction to consider the representation
Second application is filed.
within 4 weeks
Yes, sir.
from the date of production of the certified copy.
Yes.
So when he filed the contempt petition at the first instance, he must have taken averment that when he produced the certified copy, and that is how the order dated 24/2023 was passed.
The
That
first contempt application was within the
if
time.
they have not complied with,
Second
it will be complied with within 3 months. So that period you have not complied with. So what is the question of time bar? There is nothing that he has to file again a representation for complying that order.
I was just praying if this order of the first contempt is taken into consideration, the second contempt application is time.
Okay. Where? First contempt, second contempt, how will it be time barred? First you explain to
No,
us.
there is no concept of second contempt. I'm conscious about it, but since there is an standing order of this honorable, but I'll take instruction as to the compliance of it.
Because the order is very clear that if
Yes,
has not been complied with,
it
you
has
have
to be
comply with within
yes.
3 months.
Yes.
That order was passed on 24/2023.
Yes.
And he was not at all required to file any further representation or anything like that.
Yes.
Though he has filed on
An application after
39/2024, though to which you said that it is time bound. The petitioner was not supposed to file anything. You are just to comply the order which was passed.
Some time I'll take that what compliance has been done in the mail.
But only representation was to be disposed of.
Yes, sir.
Nothing in merit. So what has been done, you inform so that further steps.
I'll take instruction.
The land and council.
Representation or the payment of compensation.
See the direction first date. First date there is a direction for payment of compensation. Let us see.
No,
let us see. Let us see.
No, representation. Regarding the payment of compensation.
No, to consider the representation and pass appropriate. There is no order for payment.
Representation was the payment of.
So,
yes, sir. They may say that your representation is totally misconceived and you are not entitled to get the compensation amount.
Yes, sir.
So how do you say that there was a direction for payment of compensation? Direction was otherwise. Right, that is the thing. So let's go to the land council for the state. 6 some time. You have taken time earlier.
It was listed on
They
5
take
to
some
5
further time to obtain instruction as per order number 2 dated 6/2/2025. So let it come on
2nd April.
8th April. We are but take a concrete information in the meantime. Don't take 8/4/2025. You are getting sufficient time.
Yes.
So yes. We are just coming.
First, second, and third. No, it's
Item 21.
The contempt petition, it has come for the first time. The order dated 1/10/24. The direction was to dispose of my representation. It has not been complied with, Your Lordship, till date.
We'll take instruction, my lord. When you produce the certified copy of the order,
Your Lordship, it is at annexure 2, Your Lordship. 30/10/2024.
30/10/2024.
Yes, Your Lordship.
11/12/1 ମାନେ 30/1 ରେ ତାଙ୍କର କମ୍ପ୍ଲିଟ ହଉଛି 3 ମାସ।
Yes, Your Lordship.
ତାପରେ
ଫାଇଲ କଲେ କେବେ?
After 2 days of the completion period, Your Lordship. That is
ନିଶ୍ୱାସ ନେବା ପାଇଁ ଟାଇମ ଦେବେନି
Lordship.
ମାନେ ଏମିତି ସୁଇଚ ଟିପା ହବ ଫାଇଲ ଏମିତି ଅର୍ଡର ବାହାରିବ after 3.
Lordship, after 3 months I have filed, Your Lordship.
No, 3 months to comply.
Yes, Lordship.
Yes,
Lordship, after 3 months I have filed, Your
I
Lordship.
know, but ମାନେ 3 months ସରିଲା ଆପଣ ସାଙ୍ଗେ ସାଙ୍ଗେ ଫାଇଲ କରିଦେଲେ ଆଉ କଣ?
Lordship, but it has come after a considerable period. It's in March, Your Lordship. It's not like that I have come up in.
No, but you increase the pendency that way file करिए. By this time they might have complied also.
They have instructed the SMC to take necessary instruction for the compliance, Your Lordship. That letter they have given to me. Today morning I took instruction from the client. The client
That is what, if your client would have waited, something would have happened. But client cannot wait.
the contempt petition has been filed for non-compliance of the order dated 1/10/2024, in which the opposite party number 1, Command Collector Sambal, was directed to take a decision on the representation of the petitioner and to dispose of the same within a period of 3 months from the date of production of the certified copy of the order by the petitioner and to communicate the order to the petitioner. The learned counsel for the petitioner submits that the copy of the order has been served on the contemner opposite party on 30/10/2024. And the petitioner is yet to receive any communication regarding the result of the representation filed by him. Land counsel for the state takes some time to obtain instruction on the matter. Place this matter, put of this matter on 22nd of April 2025. Yes.
Item 22.
On behalf of Mr. Rachit Roy, may I seek one sword?
Yes.
Gratefully.
Item 23.
My lord. In the last occasion, the Lordship's order regarding amendment of the writ petition, incorporation of my representation filed pursuant to the order of the Senate Court, I filed IA 2256/2025. The Annexure 22 is not to be incorporated. Jota ki my Lordship was pointing out after the order whether you have filed.
So your interim application for amendment has come up for consideration.
Consideration, my lord.
So what amendment you are seeking for now?
Annexure 22.
Have you served a copy on the?
Yes, madam. Both the state and central council, I have served the copy. But
You have received the copy?
No, madam. You have to receive. Or to receive the copy.
You have received?
Yes.
Mr. Padi has received. Semane not received.
No, ଦେଇଛୁ। No, ସେ number ହଉ।
ନମ୍ବର ହେଇନଥିଲା ସେମିତି ଦେଇଦେଲେ।
ନାଇଁ ମୁଁ
ରିସିପ୍ଟ ଟା ତାଙ୍କୁ ଦେଖେଇ ଦିଅନ୍ତୁ।
ଆଚ୍ଛା ଏଇ ଯୋଉ ଆପଣ ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ଟା ଫାଇଲ କରିଛନ୍ତି ଏଇଟା ପ୍ରେୟାର ପରେ ରହିବା କଥା ସିଡ୍ୟୁଲ ଅଫ ଆମେଣ୍ଡମେଣ୍ଟ ଆପଣ ସେ ଆମେଣ୍ଡମେଣ୍ଟ ଟାକୁ କେମିତି ଭିତରେ ପୁରେଇ ଦେଇଛନ୍ତି ଆପଣ
ପ୍ରେୟର ହବ ତାପରେ ଯିବୁ
ତୃତୀୟ ପାରାଗ୍ରାଫ ପରେ ଆପଣଙ୍କର ପ୍ରପୋଜ୍ଡ ଆମେଣ୍ଡମେଣ୍ଟ ଲେଖିଛନ୍ତି ଏଇଆ ହବ ତାପରେ କଣ ପ୍ରେୟାର ଦେଇଛନ୍ତି
ନାଇଁ ମୁଁ ଏଇଟା ଫେଜ୍ 3 ରେ ପ୍ରପୋଜ amendment
ସେମିତି ଦିଆ ହୁଏନି
ସେଠି ଦିଆ ହୁଏନି ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ଦି ୱେ ଆପଣଙ୍କର ସିଡ୍ୟୁଲ ରହିବ ସିଡ୍ୟୁଲ ରେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଲେଖିଲେ ରହିବେ ଏଟା ପାରାଗ୍ରାଫ ନମ୍ବର 25 ରେ ଏଇଟା ରହିବ ସୋଆନସୋ ତ ସେଇ ପୋର୍ସନ ଟା ଇନକର୍ପୋରେଟ ହବ ରିଟ୍ ପିଟିସନ ରେ ବାଇ ୱେ ଅଫ କନସୋଲିଡେଟେଡ ରିଟ୍ ପିଟିସନ ଫାଇଲ ହବ
ପ୍ରେୟର ତଳେ ସିଡ୍ୟୁଲ ଟା ରୁହେ
ପ୍ରେୟାର
ବୋଧେ
ତଳେ ସିଡ୍ୟୁଲ ରହିବା କଥା ଆପଣ
ଆଚ୍ଛା ଲେଙ୍କା ସିଡ୍ୟୁଲ ଟା ପ୍ରେୟର ତଳେ ରୁହେ ତ ଆମେଣ୍ଡମେଣ୍ଟ ରେ ହଁ
Yes, that is
ପ୍ରେୟର ଲେଖା ହବ as per the schedule below
that is correct. Yes.
ଏଟା ଆପଣ ଫାଇଲ ଏଟା ୱିଣ୍ଡ୍ରୋ କରିଦିଅନ୍ତୁ ଏଟା ଆଉଟ ଫାଇଲ କରନ୍ତୁ This is an application for amendment of the writ petition. The Learning Council for the petitioner seeks permission to withdraw this interim application to file a better one. Accordingly, IA is disposed of. Yes.
Item 20.
Secondary is here. Yes. 24, Mr. Lenka.
44 madam.
IA has come for amendment.
Yes, ma'am.
देखिए
By way of
schedule
that
of
amendment, I
8 is over. Schedule of amendment. So, have you given a copy to the?
yes, ma'am. Last occasion. Initially, it was given as per the direction of the lordship on the last occasion.
Anything you have to say?
Yes, 180 every single.
No, it's all right. Anything you have to say on this, or we'll allow this?
have you gone through the IA okay it is listed for amendment you have a copy why have you not gone
से
through
paragraph से add କରିବାକୁ ଚାହୁଁଛନ୍ତି in fact replace କରିବାକୁ ଚାହୁଁଛନ୍ତି paragraph 5 of the writ petition be replaced by the following paragraph
So that the notification can
copy of the notice ଟା publish जो ହେଇଛି ओडिया newspaper समाज रे ସେଇଟାକୁ ସେ annex କରିଛନ୍ତି annexure 2 ଆଉ annexure जो ତାଙ୍କର representation ଦିଟା ଅଛି ତାକୁ annexure କହୁଛନ୍ତି annexure 3 and 4 ଏତିକି ହଉଛି ତାଙ୍କର schedule of amendment ର
that amendment copy has not been solved.
sorry
କୋଉ amendment ଦେଲେ
And
କଣଟା କରିଦେଲେ
ଏଇଟା ସେକେଣ୍ଡ ଟା ଯୋଉ 1877 ମିସକେସ୍ ଟା ଅଛି but 3198 by 25
1877 ଟା କଣ amendment
no that is not amendment I have written that 3198 by 25 that copy has not been solved
Mr.
amendment
Venka,
copy not solved
you have not given the copy
ଆଉ noting ବି ସେଇଆ କହୁଛି ନା received sorry it says received
copy not solved
copy not solved IA number 55
copy not solved
receipt regarding submission copy
IA number 318
ଉପରଟା
ଉପରଟା
ତଳଟା ଦିଆହେଇଛି
ତଳଟା ଦିଆଯାଇଛି
ତଳଟା ଦେଇଛନ୍ତି ଉପରଟା ଦେଇନାହାନ୍ତି
କପିଟେ ଦିଅନ୍ତୁ ତା ଫାଇଲରେ ବି ନାହିଁ ଲେଖନ୍ତୁ IA number 3198 of 2025 this is an application for amendment of the writ petition and counsel for the state submits that he has not received
data को दिया
अच्छी
तुम दे दी बात
out of the
data को रसीद रखू
copy of the ଗୋଟେ ପାଇଛନ୍ତି ଆରଟା ନାହିଁ ବୋଲି କଣ କରିବି
ମୁଁ ଦେଇ ଦଉଛି
ରିସିଟ୍ ଦେଖି ଏଇଠି ତ ରିସିଟ୍ ତ ଦେଇନାହାନ୍ତି ଅଫିସ ଇଜ ପଏଣ୍ଟିଂ ଆଉଟ୍
ହଁ ଫାଇଲ ବାନ୍ଧି
IA number 3198 ର
21 ଦିନରେ ଦିଆ ଏଇଟା ଦିଆ ମୁଁ ଦେଇଥିବି ଆଉ ତ
ନା ଆମକୁ ନେଇ ତାଙ୍କୁ ଦେଖେଇ ଦିଅନ୍ତୁ ସେ ଖୋଜିକି କାଢିବେ
ଫାଷ୍ଟ ଦିଆ ହେଇଥିଲା ଆଫ୍ଟର ଦ ଡାଇରେକ୍ସନ ଅଫ ଲର୍ଡସିପ ସେକେଣ୍ଡ ଟାଇମ ଦେଇଥିଲେ
ବଢିଆ ଧନ୍ୟବାଦ
IA ର copy ମିସକେସ୍ ଲେଖା ହଉଛି
କୋଉଠି
ମିସକେସ୍
ଏଟା କୋଉ ମିସକେସ୍ ଦେଲେ କିଛି ତ ନାହିଁ ନା
ଖାଲି ମିସକେସ୍
ହଁ 21 ଫେବୃଆରୀରେ ଦିଟା ମିସକେସ୍ କୋଉ ମିସକେସ୍ ନମ୍ବର ପାଇଁ there is no procedure ଏଟା we have to ask the office
ସେଥିରେ ଆଇଏ ବି ଲେଖା ହେଇଛି ଇଣ୍ଟରଭ୍ୟୁ
ନା
ଆପ୍ଲିକେସନ
ନା ଆଇଏ ଲେଖା ହେଇଛି office has to be told ଯେ ନମ୍ବର ଚଢେଇବେ
ତାଙ୍କର ଏଜି ଅଫିସ୍
ଓ ଏଜି ଅଫିସ ନମ୍ବର ଚଢେଇବାକୁ ପଡିବ you have to tell your office
କହିଦିଅନ୍ତୁ ଦେଖନ୍ତୁ ଏଇଟା ଦୁଇଟି ମିସ୍ କେସ୍ ର କପି 21 ତାରିଖ ଦିନ ଦେଇଛନ୍ତି। But the problem is that whosoever sitting there and receiving the copy is not mentioning the number. It should be mentioned so that it can be easier for us.
Find out.
ହେଲା ଖାଲି ମିସ୍ କେସ୍ ଲେଖିଦେଲେ କୋଉ ମିସ୍ କେସ୍ ଦେଲେ ଜଣା ପଡୁନି ନା, ତେଣୁ ଆପଣଙ୍କର କହିଦିଅନ୍ତୁ ଯେ ମିସ୍ କେସ୍ ନମ୍ବରଟା କମ ସେ କମ ପକେଇଦେବେ। ନାଇଁ ନାଇଁ ଠିକ ଅଛି, ଆମେ ବଡ ପାସ୍ କରି submit that he has not received the copy of the interim application. When counsel for the petitioner submit that the copy of the interim application will be served by tomorrow. By tomorrow.
In course of day, Lord's mercy.
So that in course of the day. This matter for the
Yes,
17th of March 2025. है ना? March 2025.
25 also, sir.
Copy of I8 for amendment.
So you want লেখা যে as per order dated so and so some documents not filed. Noting টা দেখতে হবে, noting টা। আর একটা correction of order type or order number. IN number
has been inadvertently instead of. এটা লিখি দিও, peruse the office note which indicates that order in the order number 24/2/2025, the IN number has been inadvertently typed as so and so instead of so and so. Let IN number so and so be read as IN number so and so. As for the order dated 19/2/2025, some documents not filed. Mr. Lenka,
My lord.
कौन से order थिला? Praised to file some documents and if necessary to file an interim application for amending.
Are those documents part of the IA?
Yes, that document is part of the that notification
Submission na note kar
regarding acquisition of land.
Submission na note kar that he has filed.
I filed it along with the IM.
The IM মানে কো আই রে ফাইল করছেন সে ডকুমেন্ট ওরা
for amendment.
ওটা তো ডকুমেন্ট ଦେଇଛନ୍ତି নোটিস
সেই গোটে document.
সেই গোটা আছে। The Land and Council, though the office has pointed out that as per the order dated 19/2/2025, some documents have not been filed by the Land Council for the petitioner. Mr. Lenka, Land Council for the petitioner submits that those documents have been filed in IA number P199 of 2025. Stop. So this will also come na. এটা amendment.
সেদিন তো কপি দিয়ে দেবে সেদিন।
Other भी copy হয় না? আচ্ছা, copy has not been received. You will serve the during course of during course of the day. In course of the day and matter to be listed on 18/3/2025. Right?
As over item number 2.
Mention is made on behalf of Sujata Jana for adjournment. Release this matter on 18th of March 2025. Yes.
Item 3.
Madam Tornantanel.
Yes, Pondana.
Item 3.
Item 3, Mr. Yes.
Mr. Kor.
Yeah.
Mr. College. Mother CG.
You want adjournment? What is your name, Land Council?
Damodar Saudi, sir.
Mr. D. Saul, Land Council, appearing for Mr. P.K. for 6 for an adjournment for 2 weeks. Is this matter? In the week comments.
My lord, extend 3 weeks, my lord, one instruction for
3 weeks. তারপরে রকি 8 তারিখ রকি 8/4/2025। Yes.
Item 22.
May I please
on the last occasion, I was placing the judgment passed by the Honorable Supreme Court in the case of Krishna Veni Rai versus Pankaj Ray and others, which has in turn relied upon the judgment of Leela Gupta and Anurag Mittal rendered by the Honorable Supreme Court. But the purpose of placing this judgment before your Lordship is impress upon your Lordship that Section 15, if a marriage takes place in contravention of Section 15, my Lord, it's not a void marriage. And the law which has been propounded in Leela Gupta, followed by Anurag Mittal, my Lord, and then Krishna Veni, it says so, my Lord. Your Lordship, my Lord, your straight away, Lordship, may kindly see the case of Anurag Mittal.
Yes, just into marriage. Let us see your date chart.
Yes, ma'am.
Please place it on that date chart.
Yes, ma'am. But on 22nd 11/2019,
Yes, please place that.
22nd 11/2019, my Lord, the decree of divorce is passed by the Learned Family Court, my Lord. On 7/1/2020.
No, the just in that CP.
Yes, my Lord.
Who is the
husband?
Husband.
The respondent in the matter.
Okay. Husband filed the divorce petition.
Yes, my Lord.
And the who is the other side? That means there is Yara na Kontila.
Subhashini Maharana.
Achha, that was filed against Subhashini.
Yes, madam.
Subhashini Maharana. Okay. So that was allowed and marriage was dissolved.
Dissolved. And the husband was directed to pay a permanent alimony. Being agreed by the permanent alimony part, the husband preferred an appeal on 7/1/2020. That is matter number 4 of 2020.
7/1 later लिखना ही नहीं है.
My Lord, your Lordship, I had given a separate date chart.
अच्छा, okay.
Fresh date chart.
Fresh. 7/1/2020. It was filed against that amount
yes,
which has been
alimony.
Permanent alimony.
Yes, sir.
All right. Then she filed a matter.
She filed matter 13 of 2020 on 21/1/2020.
Right.
Challenging the decree of divorce. But during pendency of the appeal, both the appeals were not. On 22nd February 2020, the respondent, that is the husband, in the appeal preferred by the wife, Pramod Sahani, he got married, my lord, to the review petitioner.
So that means during pendency of
the appeal, my lord.
Both the appeals.
Yes, ma'am.
Okay. And this 21/1/2020, which the Subhashini Maharana challenged it, in that matter, notice was issued when? To the husband, Pramod Sahani. Whether that record is available, matter of 13 of 2020.
Notice was never issued, but straight away, my lord.
No, we are just to know that whether
yes,
after receipt of the
notice.
A
very vital. Yes, my lord. No, my lord. On 7/3/2022, the Honorable High Court permitted the wife, Suhasini Maharana, to take steps for substitution, keeping the question of admission open.
No.
She must have filed some document showing that he has died.
Yes, ma'am.
That is right.
Yes, ma'am.
No, ता पूर्वरु जो बाहा हेले प्रमोद ता भितरे ए जो माटा 13 20 रो नोटिस जाइथिला सेटा हम जानिया होतो. record ଅଛି
record हाँ 13-20 ना उठे नहीं
ଅଛି
certified copy of the order ଅଛି
नहीं
soft copy of MATA yes it is there
ମାଟା 13 ରେ ଆପଣଙ୍କର ଫାଇଲ ହେଇଛି 21/1/2020 ରେ तो अच्छा it was listed for the first time on 14/9/2020 then on 22/3/2021 and अच्छा notice ହେଇଛି 23/3/2021 ରେ 23/3/2021 so to the appellant issue notice to the appellant अच्छा submit that her name may be deleted oh अच्छा that is fine no then it a notice no अच्छा wait for अच्छा तमें टोटल नोटिस ही नहीं है केस है माने whether what I just want to ask you that whether knowing that the wife has challenged you have married or not but it appears that in MATA number 13 of 2020 no notice has ever been issued to the husband.
That's very vital.
That is very, very vital.
Mr. Rai,
Yes, ma'am.
this Lily Gupta which you have filed, I think that time section 15 was different.
Yes, ma'am. There was a proviso.
There was a bar not to marry within 1 year.
Yes, ma'am. That has been followed in the case of Anurag Mittal, madam, where the Honorable Supreme Court interpreting the main provision of section 15.
Now let us see, come to that very provision.
Yes, madam.
Where it says that during that period you should not marry. You appeal, which is that provision?
Section 15, madam.
When a marriage has been, please paste it, section 15.
Divorced persons, when may marry again, madam? When a marriage has been dissolved by a decree of divorce and either there is no right of appeal against the decree, or if there is such a right of appeal, the time for appealing has expired without an appeal having been presented, or an appeal has been presented but has been dismissed, it shall be lawful for either party to the marriage to marry again.
Okay, no, we are asking you, suppose the appeal has been presented in time.
Yes, sir.
And during the, while the appeal was sub judice, you have married. But the husband is not aware that such an appeal has been preferred. Because the husband, wife has preferred the appeal. So husband is not aware. So whether he has to, in this way, whether he has to check.
That is another aspect, my lord. Again,
whether my wife has filed the appeal or not, so that I can
remarry. What the Honorable Apex Court has held, my lord, since section 15 only creates an embargo, does not say anything that in breach of section 15 if a marriage takes place, what would be the consequence? So therefore, it does not render a marriage void. And my lord, Hindu Marriage Act has section 11 and section 12 says under what circumstances a marriage can be declared as void and under what circumstances a marriage
follow that. But so your point, suppose as we say that he is not aware.
Yes, madam.
That my wife has already challenged the divorce decree. So under that impression, he has married to this lady.
No, either or that time has to expire. If the time has not expired, also he should not. Once he will check. Other is the time has not expired, he should not marry within that time.
The appeal has been presented and the time appeal has expired. So what is the time according to?
I got married after on the 92nd day, my lord. After 90 days.
After 90 days?
Okay. So इसलिए last time I was slightly confused whether the
जो order sheet था जी The divorce decree ta jadi hela kod
After 90 days, but in the meanwhile, she had filed an appeal.
In the meanwhile, she had
Interesting,
filed an appeal.
interesting point. Okay.
So no list of date re ଆପଣଙ୍କର ଡିକ୍ରି ହେଲା 22/11/2019 ତ ଆପଣଙ୍କର ଏଇଟା ହଉଛି କେତେ ମାସ ହଉଛି ଅପିଲ ଫାଇଲ କରିବାର
90 days calculate kale.
No, you have filed married after 90 days, but
Yes,
ये जो appeal file कला के दिन रे?
appeal
ଫାଇଲ ହେଇଛି 21/1/2020
But
ମାସର
section
ଇଏଟା ଦେଖିଲି
section presented, no?
ଏସଆର ଟା ଦେଖୁଛି it's a valid presentation କହୁଛନ୍ତି କାରଣ ସେ limitation ଦେଖେଇଛନ୍ତି 90 days the appeal was filed within 61 days so therefore it is within the period of limitation so 90 days ହଉଛି ମାଟାର 13 of 2020 ର ଏସଆର ଦେଖିଲେ ଏହା ଜଣା so appeal was filed within time but it was not within the knowledge if you interpret it in this that way because notice has not been issued so had the notice been issued it would have known or at least he should have communicated that I have filed such an appeal before the court and a type of interpretation judgment ଅଛି ଏ type ର ଦେଖନ୍ତୁ କାରଣ ଆପଣ ସପୋଜ ସିଏ ବର୍ଷେ ହେଲାଣି ଫାଇଲ କରିଦେଇଥିବ ହଜବେଣ୍ଡ କୁ ଜଣେଇ ଚୁପଚାପ ବସିଗଲା ଆଟଲିଷ୍ଟ ଗୋଟେ ଆଡଭୋକେଟ ନୋଟିସ ଦବା କଥା ଯେ I have challenged the order because he is supposed to be aware that such a provision is there that husband can marry the provision section 15 so I have already challenged a ଜିନିଷ ଯଦି husband ର notice କୁ ନ ଆଣିଲା ଆସିଲା ତାହେଲେ if he marries after the appeal period is over whether that can be said that he has contravened the provision एक तो notice issue ହେଇନି ମାଟାରେ ଦ୍ୱିତୀୟ କଥା କୌଣସି communication ହିଁ ନାହିଁ husband କୁ ଯେ wife already challenge କରିସାରିଲାଣି ସେଇ circumstance ରେ after 90 days if the husband is getting married then whether to say light ରେ ଆପଣ ଦେଖନ୍ତୁ
May I pray for one thing, my lord?
Yeah.
But if your lordship is convinced so far as the fraud part is concerned, at least let notice be issued on the review.
We are not concerned on the fraud part. When you have proceeded in your way, they have proceeded in their own way. Because can you show to us that they were aware of the marriage? Had you sent the invitation card or what?
That is the judgment of the Supreme Court, my lord.
Yes, what?
Honorable Supreme Court says, my lord.
Yes. Supreme Court is on a different point. Says that if a marriage is
Honorable Supreme Court says in the case of Yalava versus Shantava, probably this must have made your lordship's mind at the time of entertaining the matter, my lord, in the absence of the husband.
No. Husband is dead, so as simple as that. It never crossed our mind that must have married or anything.
No, even your lordship is right because the Supreme Court says the property rights are...
And also it was presented within time.
Yes, ma'am. Lordship may kindly see paragraph 6 and 7. In paragraph 7, that it is incumbent on the part of the spouse to implead the legal heirs. And what she does over here...
Legal heir daughter, she has impleaded.
She only impleeds the daughter who has been staying with her. She does not impleed me, even if not me, at least the husband's father who was alive by then, she being the daughter-in-law.
Class 1 here is who? Class 1 here is who? Not the parents of...
All the legal, it doesn't speak about any class of heirs.
All the legal heirs means brother, sister, everybody then.
All other legal heirs of the deceased spouse who are interested in getting such a decree maintained to be joined as necessary partners.
So are parents interested in a divorce decree?
One really cannot say, since the father is also dead and between so, but at least suppose if my marriage is held to be not void, the review petition marriage is held to be not void, in that case, I should have been rightly implemented as a party.
Aggrieved spouse should be allowed the opportunity.
As on date, even I am also legal because her marriage was dissolved. Unless it was set aside by this honorable court.
View that since divorce proceedings.
Paragraph 7, my lord.
If you would not survive for challenging the cannot be sustained. Oh, yeah, you are saying right. Because of this, we had entertained.
we want to interpret in this way, whether the mere presentation of the appeal in a case of this nature, challenging the divorce decree is sufficient, or the knowledge of the husband that the wife has already filed, that is also a paramount consideration. So,
I'll examine.
Because the statute is clear, it says presentation, but different courts may have interpreted in different ways.
Yes, madam.
in that way, because if suppose it is kept filed, it is in defect ରେ ରଖିଦେଲେ ତାପରେ ସିଏ ବାହାଘର ହେଇଗଲା, ସିଏ ବି ଜାଣିନି ଇଏ ହେଲାଣି, ତାପରେ ହଠାତ୍ ଡିଫେକ୍ଟ ରିମୁଭ କରିକିନି ଆଣିକିନି ଇସ୍ୟୁ ନୋଟିସ କଲା ବେଳକୁ ଏଇ ଜିନିଷ ଗୁଡାକ ହବାର ପସିବିଲିଟି ଅଛି। So there must be a type of situation ଯଦି ଆସିଥିବ ତାକୁ ଇଣ୍ଟରପ୍ରିଟ କରାହେଇଛି କୋଉ ୱେରେ। ତ ଯେ ଯଦି ବି ତମେ ହଜବ୍ୟାଣ୍ଡ ର ନଲେଜ କୁ ନ ଆଣୁଛ, ତାହେଲେ ଏଇଟା କଣ ତାର କନସିକ୍ୱେନ୍ସ ହବ। ହଜବ୍ୟାଣ୍ଡ ହଉ ବା ୱାଇଫ ହଉ, ଯିଏ ବି ହଉ, ଯିଏ ରିମ୍ୟାରେଜ କରିବାକୁ ଯାଉଛି, ତାର ନଲେଜ କୁ ଅଦର ସାଇଡ who has challenged the order in the appeal, he has to bring it, because there is a provision that the other side can remarry. So if he has already taken steps and the matter is not getting listed for some reason, maybe for defect or whatever it may be, or it may take some time for admission, it is to be brought to the knowledge of the other side. Otherwise, he may have no information that the other side has already preferred the appeal. So in that way, if any such, କାରଣ ସେଇଟାକୁ ଯଦି ସେ ହର୍ଡଲଟା ଆପଣ କ୍ରସ୍ କରିଯିବେ, ତାହେଲେ ରେକର୍ଡ ଦେଖଉଛି ଯେ ନୋଟିସ ହେଇଛି, ତେଣୁ you had no knowledge. So once you have no knowledge, there is no the marriage can be said to be quite justified. Then all other consequence should follow. ସେଇ ଲାଇଫରେ ମଧ୍ୟ ଦେଖନ୍ତୁ ହେଲା।
There may be decisions on both
sides.
might be it is your duty to find out, or it is you should get notice. It will be interesting.
May not notice may not be in that case, but at least the advocate notice that such a petition is filed, but it is yet to be
after reading this, I feel it's essential that we file matter. We don't file any application, supportive application. At least I have not filed. But now it is essential that a supportive application should be filed for stay.
No, it's not necessary. That is the problem. If you filed it within time, it is not necessary. When it is, in fact, we have seen cases when it is limitation, then they are filing application for stay, because without that order, it won't operate as automatic stay.
No, even when like Supreme Court has said section 15, my lord, if a marriage takes place in contravention of the main provision, now the proviso is gone, which provided 1 year embargo. Supreme Court says that then also the marriage is not void.
It's all right.
That is totally, we agree with you, right? But we just want to examine this. Since it has come, let us give a decision on this. But it's a very interesting point, and the Mr. Rajit Royal and counsel appearing for the petitioner placed 3 citations before us. That is in the case of so and so thing type of decision like this. The citations are taken on record. He placed the date chart. Which shows that the Learning Judge Family Court Baripada passed the divorce decree in favor of the husband in civil proceeding number 206 of 2017 on 22/11/2019, dissolving the marriage between Pramod Kumar Sahani and Subhasini Maharana, with a further direction for grant of permanent alimony. Kete amount basically
15 lakhs per hundred. Very sure.
Matter thivo or 15 lakhs, you are right. With a further direction to provide 15 lakhs to the respondent wife as permanent alimony. তারপরে পরে আসলে রিভিউ করছিল।
That also must not have been paid.
Right.
So another
Yes, yes,
another interesting point will arise whether you will pay.
The order which was passed for payment of permanent alimony was challenged by the husband Pramod Kumar Sahani before this court in MATA number 4 of 2020 on 7/1/2020, whereas the wife challenged the divorce decree by filing MATA number 13 of 2020 on 21/1/2020. Stop. Section 15 of Hindu Marriage Act 1955 reads as follows. The stamp reporter in MATA number 13 of 2020 has pointed out that the limitation period of filing the MATA is 90 days, and the MATA was filed by the wife within the period of limitation. Stop. However, we find that till the date of the marriage of Pramod Kumar Sahani with the petitioner Gargi Biswas, no notice has been issued.
Matter has not been listed or is that?
Listed
Listed in the listing.
The matter has neither the matter has not been listed, and thus it can be said that the prima facie that Pramod Kumar Sahani has no knowledge that Subhasini Maharana has challenged the divorce decree passed by the family court in MATA number 13 of 2020. The Land Council for the you are to satisfy also that whether he has not obtained, because you have not taken any ground in this slide, the discussion which you have made, that advocate notice has also, because this is the matter of record, yes, which we just dictated. So far as the advocates noted after filing of this one, so that also that knowledge dita pakra asthio, either notice ele asthio, court or notice jota heini, ଆଉ ଗୋଟେ ହଉଛି suppose filing କଲା ପରେ within time advocates notice ଦିଆ ହେଇଛି ଯେ ସେଇ part ରେ ଆପଣ କିଛି ଲେଖି ନାହାନ୍ତି, averment ନେଇ ନାହାନ୍ତି. However, there is no averment in the review petition that any intimation has been received by Pramod Kumar Sahani by way of advocate's notice about issued on behalf of the Subhasini Maharana regarding filing of MATA number 13 of 2020 before this court. The question that crops up for consideration is whether, in terms of section 15, mere filing of the appeal would debar the aggrieved party, would debar the person in whose favor the divorce decree has been passed to marry again, or the knowledge of filing of such appeal on his part is necessary. Mr. Royal and counsel for the petitioner seek some time to examine this point, put up this matter on Keberakyoto. This is the point we are formulating. The Khalif appeal hejibo, filing hegale eta hejibo, Asia bahai karibu, another knowledge भी दरकार. Yes, see point रा अपन देखो see section 15 आसी जीवो decision की बोनिशा. Yes, sir. So next week ना Okay. Keberakyoto. 18 next Wednesday, madam. Next means on 18th today. 19th. All right. Let's put up this matter on 19/3/20. You get the order in the evening hours. Now we make a little change what we have dictated, but get the change and accordingly prepare yourself, right?
Are they there the weekly list? Nice. Okay.
He is under jail custody for more than 10 years.
Supplementary list item number 1.
On behalf of Mr. Ratho, permitted to bless this matter. The present appellant is in custody for more than 20 years now. And also, all the accused persons have been acquitted except this appellant. This appellant has been convicted under section 302 and 394 and has been sentenced to undergo RID. And that duration of 14 years and 20 years have already gone. Therefore, this is an application of under section 389. Therefore, looking into the custody, my lord, you have seen only once, my lord, he was released on bail, on interim bail for his daughter's marriage.
मैंने तो आपको छोड़ जाए तो ये पे what is his 20 years of age? I'm gonna hearing list and not la paper ready.
Trial court record 31.
Order for profit, acha ransom.
So the final form shows that Yudhishthir Meher, the
ଆପଣ ଥରେ ମନା କରିଥିଲେ 1908 2014
Case is also
Directed for final hearing.
27/8/2004, the date of custody. So you are never released on bail during trial.
No.
Just a minute, let us verify. Register production custody. Register production custody. Yes. Order state production custody. Yes, he was never released on bail during trial. And date of custody as per final form is
26/8/2004.
27 you are produced before court. 27/8/2004. And in this appeal, how many times you have been released on bail? Or never released on bail?
One rejected.
On interim there. The daughter's marriage, my lord, he was released on interim there. For
one thing, he is right that he was never released on bail during the trial, as it appears because the trial court record is available. But during that period of COVID, he might have been released. So just obtain that custody certificate.
Maybe parole and all that.
Parole. কারণ 20 বর্ষ কিছু কম গিয়েছে the IA number 35 of 2025 is an application for bail. Land counsel for the petitioner submitted that the petitioner was taken into judicial custody on 27/8/2004 and he was never released on bail during trial. And during pendency of this appeal, his bail application has been rejected twice. That is on 19/8/2014 in this case number 120 of 2012 and 14/12/2018 in IA number 72 of 2018. However, he was granted interim bail for 2 weeks, a period of 2 weeks on in IA number 35 of 2021 as per order dated 22/4/2021. And as such, the petitioner has remained in custody for 20 years. Let the Land Council for the state produce the custody certificate. Put up this matter. Eta who jail ochandi?
Sohela.
Sohela. So
Sub jail Sohela.
yes, ma'am.
So next week.
Divi.
July 11.
25
25th we are keeping. Put up this matter in the week commencing from 25th March 2025.
On 20.
Oh, sorry, on 25th March 2025.
Item 2.
Let 11/9/11 I was in custody. Lordship called for the status report and my conduct and the duration of stay. Last time it has been directed.
11/9.
2011. Last time its duration was issued.
That's
Yes, right. And also the health condition report on each either. Encountered Millers. One leg is virtually non-functional from the day one. You were released on interim bail? No, never. Once my bail application has been rejected. That is the order dated as it appears 21 10 2020. In this case,
That is the only time.
9. So as per the last order, Mr. Mantri, you are to produce the custody certificate and health condition book.
Letter of issued is not received. I pray for 7 days time.
And conduct of the petitioner on parole. So 3 things you are required to do as per that order.
As per order today.
Get it.
11th month.
Antecedents aanichandi.
That is there on record.
That is-
Affidavit, clarification
That is
affidavit has
on-
also been filed. When the last time it was heard, it's on record.
Antecedent is there.
The IS number 1896 of 2023. Learning Council for the state seeks some more time to comply the order dated 11/2/2025. In producing the custody certificate of the petitioner to obtain instruction regarding the health condition from the concerned jail superintendent and also the conduct of the petitioner while he was on parole. Put up this matter on 25th of
think
Mr.
this-
Devasi Sonangi.
Directly final hearing ke se adjourn kori tabe bache.
It was 1.5 years before when minor, ULFC was there, minor the Chief Justice.
1 year.
1 year. Then
Final hearing, then it
twice,
was-
twice.
You are appearing for.
Right.
I am for the informant.
What is your good name, Land Council?
Sushant Harichandan.
Mr. S. Harichandan, Land Council for the informant. No? Persistent just. Yes.
Item 3.
virtual mode.
Mr. Tripathi.
Yes, my lord.
So last time when the matter was taken off,
The company actually producing the history more miller.
No, it is it.
is the prisoner petition in which request has been made to appoint Smruti Ranjan Mahapatra advocate in place of Swan. Mahapatra is no more.
Achandi. Okay.
मनोज बेहरा अनम्यूट करूँ आमे जा कहूँ शुणी पार्छन्ती मैडम देखिए ओके मनोज मेहरा हाँ ये आपण गोटे बिजनु गोटे पिटिशन देइथिले गोटे दरखास्त देइथिले जेलु जे आपणकर जो वकील थिले आशुतोष त्रिपाठी तांको बदल रे स्मृति रंजन महापात्र को आपणकर वकील नियुक्ति करिया पई देइथिले किंतु आ भितरे एडवोकेट स्मृति रंजन महापात्रंकर परलोक हे गलानी तेणु वर्तमान आपण कोन चाहुचंती
सारे मो तो प्रथम वकील थिले सारे आशुतोष त्रिपाठी ही रही
से जानिया पई आपण लेखो मिस्टर the appellant as per the order dated 4/3/2025 the appellant appeared through virtual mode from the jail and submitted that he wants to continue Mr. Ashutosh Tripathi as his advocate. ठीक है, Mr. Tripathi, you can place the matter. There is no problem.
Yes.
You want to place it today or you want to place it some other day?
Today, my lord.
Okay. And the name of Mr. Smruti Ranjan Mahapatra shall not be reflected in the cause list henceforth. Yes. It's your matter. Whether the bail application has been earlier rejected?
Yes.
Yes, my lord.
When?
Interim bail order thila, my lord.
Order number dated 6 and 5/3/2024.
No. Your bail application was rejected as it appears on 10/8/2020.
Yes, my lord.
Then
Order number 5/10/8/2020.
right. Then you are
Interim
granted interim bail for 10 weeks. Acha. 10 weeks.
Mother was ill.
On 5/3/2024. Okay. अच्छा मनोज बेहरा ये जो आपन को जो 10 सप्ताह ପାଇଁ जो बेल दिया हितला आपनकर मांकर देह खराब नहीं किनी आपन सेटा को जाइथिले बेल ले जाइथिले इंटरिम बेल ले
आज्ञा जाइथिले
अच्छा
Surrender certificate.
सरेंडर सर्टिफिकेट अछि
फाइल order number 6 20/5/26.
अच्छा 25 रे Alright. So, what was the conduct of this man while he was on interim bail?
That I do not know. Conduct is not.
And what period he has remained in custody? That custody certificate you
Madam.
also obtained? Left on. Let the Learned Counsel for the state produce the custody certificate of the appellant and also obtain inspection from the inspector in charge of which police station? Kishore Nagar police station, regarding the conduct of the petitioner while on interim bail granted by this court as per order dated 5/3/2024 in IA number 666 of 2023. Put up this matter on 25th on 25th March 2025. So मनोज बेहरा आज जो केस बेल पाई उठी थिला सेथरे आपनकर ऑर्डर हैला जो आपण केते दिन जेल रे रहिचंती से भी तार गोटे सर्टिफिकेट जेल सुपरिटेंडेंट देबे आ द्वितीय कथा होची जो इंटरिम बेल रे जाइथिले से समय रे आपनकर को टाइप रो आचरण थिला किसी क्रिमिनल एक्टिविटीज करथिले कि नाही ए संपर्क रे किशोर नगर थाना रो आईआईसी को गोटे रिपोर्ट कॉल पर हैला सरकारी वकील हाकू आनिकिनी रिपोर्ट पहुंचेबे तापरे आपन को केस पुनी 25 तारीख दिन विचार हो बेल सुनाणी 25 मार्च 2025 दिन सुनाणी
वकील करिवे
वकील आउ करिवे से दिन आपन को रहिबा दरकार नहीं है ना यस नेक्स्ट
Item 4.
ये कर दियो डिस्कनेक्ट कर दियो
Last according Lordship directed me to file an affidavit before this annual court.
What affidavit?
Affidavit regarding
The appellant Sabyasachi Mishra filed an affidavit in person explain. Just a minute, let us go through. Yes, you are supposed to file an affidavit that appellant Sabyasachi Mishra. Where is that affidavit? Where is the memo you said you have withdrawal memo?
Not found. I will look.
ଆଉ ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି 25/2/25 flag F.
ଆଜ୍ଞା।
You see, if there would have been some other advocate, matter is different. It is your chamber. So this is not the way. The consequence could have been otherwise, as we explained to you, because the first criminal appeal, which was filed by the appellant, in that case, I think the 3042 has been altered to 304 Part 1 and sentenced to RI for 10 years. So, in case, suppose after 10 years, you would have been released from custody. And again, in this appeal, on merit, you would have dismissed the criminal appeal. Then what would have happened? So, and state councils, Mr. Mahanti and Mr. Nayak, we are bringing you to in old jail criminal appeals. In one case, we decided the matter on merit jail criminal appeal and passed the judgment in open court, and the appeal was dismissed. And then the report came that he has already been
Released, no?
that is that 430
Remission.
he has been granted. So it creates a very unhealthy practice. Once you are releasing the person, you have got power, the state has got power, and if you are doing that, then it is supposed to be communicated when the appeal is pending and you are exercising the power. There is no bar in it. You can exercise. You can, but the thing is that it should be intimated to the Advocate General office, and it should be placed before the court when the matter is taken up. Otherwise, we'll decide the appeal on merit and we'll dismiss. But by that time, the London district judge has said that sir, he has been released because. So this is the situation which, and this is another situation which we are facing today.
In fact, that case where there is in 20 years he's in custody, that is why we called for a report in case something has happened in the meanwhile.
One case, your lordship called for report from Sundar Ayapadu, that is the 2019 CRL in a reference, he was released in 2019, still matter.
That is exactly.
While my submission is for lordship as a judicial order so that it can be.
No, judicial order
is there.
That is already there, and your that scheme particularly, that scheme is there that you can exercise that power. Which case you will not exercise, that is there. After how many years you are and what are to the factors, that is very clear. I think Mr. Arupananda Das has given you that.
Legal service authority.
Yes. So question is that if somebody has been released and the appeal is pending, that should be brought to the notice of the
Initial time on the
In fact, some of those old cases about 3 years back, we had asked the state to take instruction in all the cases regarding whereabouts of because some cases the accused is dead also. So why should we hear an appeal where the person is dead? So that time all those letters used to go as soon as a case used to be listed. I mean, even before it is listed also, all old cases you should get instructions through the SP. Hearing list.
as per the order dated 19 to 20. But Mr. Mishra, be careful in future. This should not be repeated. As per the order dated 19 to 2025, has filed an affidavit explaining under what circumstances the present criminal appeal was filed, even though the earlier appeal filed by the appellant Prashant Meher in CRLA number 377 of 2018 was sub judice. The affidavit is taken on record. Since unconditional apology has been sought for by the Land Council, we are accepting the affidavit, and a memo of withdrawal has been filed on dated 25 to 2025. Accordingly, the criminal appeal is disposed of as withdrawn. Yes.
Item 5.
If you directed the government to take instruction whether there is any criminal act and the violated any order, when he was any interim bail matter. And he also directed to serve the extra copy. I have already served the
We have received, but the instruction not received refer only 5 days. That we have only 5 days. So we have contacted with him that the instruction we have not received.
You want some more time?
More time, 5.
But it's a question of ground of element of the
That
parents of
I am concerned that. That's what we have already.
No, recently the decision has come in the live law. It is there that such type of cases where the it should not be kept pending for months together, because if a very particular purpose somebody is so either you take the instruction and dispose of it an earlier.
Only 5 days.
You're asked to get instruction regarding the element as well as the conduct of the petition. So you've not got any instructions. Have you called for?
Yes.
So 18th we are keeping this. IN number 560 of 2025 is an application for interim bail on the ground of element of the parents of the petitioner, and counsel for the state submits that though he has received the copy of the interim application along with the medical documents from the Land Council for the petitioner, and instruction has been sought for but seems yet to be received, and the matter may be taken up next week. This matter on 18th March 2025.
Every year he is being released and he is
3 times a year.
surrendered on time.
That is there.
Yes.
So the conduct also
conduct.
you are, yes.
Problem.
Item number 6.
On the under section 302 IPC 27 and 25 of our sentence is live imprisonment. I am prepare the date that is
Is it your first application or earlier rejected?
yes.
First application. So you have been found guilty under what offense?
302, my lord, on the
302
circumstance and evidence.
And 25 1A and 27 1 of the Arms Act.
Website margin that
So where this occurrence takes place in where, which area?
Shugura,
Jharsuguda. Gunshot injury.
gone for the injury.
What about the criminal antecedent?
We are not obtained the criminal antecedent.
You have not obtained. No, in this type of case, you are required to obtain. Get the criminal antecedent. Jharsuguda and say gunshot injury. The Land Council for the petitioner, appellant has filed the date check which is taken on record. Let the Land Council for the state obtain instructions regarding the criminal antecedent, if any, against the petitioner. It is like the IN number so on. So this is an application for bail. Out of this matter.
He belonged to Jharkhand.
He was staying at something.
25. अच्छा ये लोको बाहर लोको.
Yes.
अच्छा I would look on it. He has also to obtain instruction whether since the petitioner is a man from state of Jharkhand, whether the address furnished by the appellant in the cause title is correct or not. In that regard, the superintendent of police of Jharsuguda shall make necessary communication with the superintendent of police of Basti Zone 3 Phase Nagar, Adarsh Nagar. Acha.
Sonari.
District Hochi Superintendent of Police West Singhbhum. The state of Jharkhand. 25 को रखू छु है ना get the instruction.
One more thing I want to bring on. I have given the deposition of PW1 to 12 to the state council, and I have also the same deposition. But unfortunately, I do not have the PW 21, 22, 23 deposition. So that I may be allowed to collect from the registry.
The Land Council for the petitioner trial court record has received here. Land trial court Land Council for the petitioner submits that she is not having the deposition copies of PWs 21, 22 and 23. Let the registry supply the deposition copy of the aforesaid 3 witnesses in the pen drive of the Land Council for the petitioner. Yes.
Item number 7.
Finance be ordered to 19/2/2025.
19/2.
Yes. The appellant has earlier preferred an appeal which is pending. Okay. That is on record.
Rita Gochi Aschi.
Yes.
Jail criminal appeal ta dekhega.
Jail criminal appeal की paper book ही ready है.
Jail criminal appeal will sometimes not possible to know. So let us see.
Advocate की गायत्री दास अच्छा.
Engage कराइएको.
आम्ही केस लिहिरायची मी गायत्री बाई.
Engage कराइएको.
What date she was engaged?
अच्छा contact करते
31/8/22. तार कौन 10 वर्ष practice है ना?
जଣା नहीं. लिखा है कि enrollment number. Get a Sila appeal petition. ଆସିଛି 27/12 ଏ ଯୋଉ ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲଟା 27/12/2021 ସବୁ ଇଏଟା ଅବଶ୍ୟ ଇଲିଟରେଟ୍ ଫେଲୋ ଇଲିଟରେଟ୍ ଫେଲୋ LTI ଦେଇଛି ଓଡ଼ିଶା କଟକ ଠାରେ କେସର ପୁନର୍ବିଚାର କରିବାକୁ ଚାହୁଁଛୁ ମୁଁ ଅପିଲ କରିବାକୁ ଚାହୁଁଥିଲି କିନ୍ତୁ ଅର୍ଥ ହଉ ଠିକ ଅଛି ଏଇଟା ହେଲା 27/12/2021 petition ସେଟା JCR
What do you say? The jail criminal appeal is already pending against the self-same impugned judgment. So, and counsel has already been engaged. So, why don't you, because this criminal appeal has been filed and the stamp reporter has pointed out that there is delay of 1313 days, right? So, again, all these things are to be gone into that delay condonation. Why don't you ask your client to send a petition from the jail requesting that you are to be engaged in that JCRLA so that you can trace that JCRLA and will disengage Gayatri Das and engage you, and that paper book is also ready, so that can be expedited.
So has he sent the petition?
I have said that I have obtained.
No. Has the petition been sent? Then we can ask the case to be listed.
No, I mean the affidavit was on. I have started over and telephone.
No, affidavit is not necessary. That letter from the prison, if it comes.
He said a contact with his father.
Which jail he is now?
Montaran.
Bolangir. Now in Bolangir.
So appearance करे तो हटा ली मत
petition ଟା ପଠେଇ ଦିଅନ୍ତୁ
कोसी कुछ मो बापा को जणे भी सेमती ले हम ऑलरेडी पेपर
କାମଟା ସରିଯାନ୍ତା କାଲି ହେଲା ବେଳକୁ ଆରେଞ୍ଜମେଣ୍ଟ କରିବା ପାଇଁ ଡିଫିକଲ୍ଟ ହବ ମେ ବି ନେକ୍ସଟ ଟ୍ୟୁଜଡେ
you do one thing let that appellant appear to virtual mode from that jail. Contamanji jail is now there, so we just clarify the position to him.
To whom he want to engage. And in the meanwhile, if the letter comes, well and good.
Just so that
Data case can be listed next Tuesday.
Separately list with
list.
लिखंतु on perusal of the records of JCRLA number 2 of 2022, we find that the paperwork टा देखी same judgment authority check कर दो
से जो लीगल एड एंगेज है କିଛି करनांती जाय रखो
एटा आपनकर क्रिमिनल अपील नंबर कले 131 क्रिमिनल अपील हला जजमेंट होची एडिशनल सेशन जज कंटावांजी डॉक्टर पवित्र मोहन सामल ठीक अछि जजमेंट डेटेड हला 16/4/2021
ठीक अछि
ST केस नंबर सेशंस केस नंबर 6/2018 ठीक है देखो on perusal of the records of so and so JCRL number JCRL it appears that the appellant Vichitra Benia preferred the said appeal against the judgment and order dated 16/4/2021 passed by the London Additional Session Judge Kantavanji in Sessions case number 6 of 2018, which is also impugned in this criminal appeal. Stop. In the jail criminal appeal, paper book has already been prepared, and the stamp reporter has pointed out that there is delay of 1 to 53 days in filing the criminal appeal. In view of the state of affairs, let the Land Council for the state instruct the concerned jail superintendent to ensure the appearance of the appellant to virtual mode on 18th of March 2025 at 2 p.m. So that the petitioner can be engaged in the jail criminal appeal in place of already engaged counsel to as the advocate for the appellant. A free copy of the order be handed over to the Land Council for the state. Yes.
जेल क्रिमिनाल अपील रे हमें माने
Engage
ये होची हमें जो एंगेजमेंट होची ताको से पिटिशनर को इन्फॉर्म कर दो से जानि परलन तो से आउट फाइल कर दो चलते ना
Secretary would you डाकिए Odisha High Court Legal Services କହିଦେଲେ ସିଏ ତ
ऑर्डर थाउ न थाउ से जणे देबे फॉलो अप करी
नहीं लीड डॉक्यूमेंट
Item number 8.
Lordships. Lordships, item 8, I pray for some time, Lordships. Lordship was pleased to hear this matter. And my line of argument was because of the medical negligence or because of the not untimely treatment. That is the reason the victim had succumbed. Because the incident took place on 20th. She was treated as an outdoor patient and otherwise. Your Lordship was not inclined on the last occasion, mainly on the ground that he's only stayed for 4 years, Your Lordship. So may I pray, let it come some other day.
No, you meant to say that if better treatment facility would have been provided to him, he would have survived. Therefore, this case would not come within Section 302 of the Indian Code.
I'm trying to make out a case, Lordships, but there are eyewitnesses to the occurrence who have seen him stab. So I am not in a very good footing, Your Lordship.
Including the doctor.
And Your Lordship had pointed out 299, Section 299 on the last occasion as well.
Sure.
That is the reason I am not, Lordships, may I pray, let the bail be lie over, let be heard on some other day. Your Lordship had pointed, I understand, Your Lordship. Section 299 provides stays at me.
Explanation 2. Where the death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death.
Lordships.
Although by resorting to proper remedies and skillful treatment, the death might have been prevented.
Lordships. I understand. That's
गाँव रे गोटे घटना हला आपन कहबे आज्ञा ताऊ जदी आनिकिनी अमको हॉस्पिटल रे कटक रे नले भुवनेश्वर रे इमिडिएटली चिकित्सा कराई थांदा से बंची जाई थांते तेणु एटा 302 केस में से गाँव रे गोटे ट्रीटमेंट करिले
नहीं गाँव में again she was treated
and discharged
and then again she went to the same hospital, again discharged. So the injuries have also increased in the meanwhile, which is Lordships, I understand it may not be a good case. Lordship may let the bail lie over, let it be heard some other day, Your Lordships, as per Your Lordship's board's convenience.
Mr. Pratyushan Naidu, thank you.
तार प्रेयर कर देबे
On the prayer of Mr. Pratyushan Naidu, list this matter. केबे रखियो आपन कोन
Lordships,
IN number
a month or so because it's
April.
April.
Is this matter in the
end week of April, Lordships?
29th of April 2025. Yes.
again यदि फल और लेना
My lord,
फल करो 10 वर्ष नथियो
my lord, I'm appearing through VC, my lord.
Yeah.
My lord, can I request this matter to be taken up next week? My lord, I have not been supplied with a paper book, my lord.
Paper book has not been prepared. Question is signed the last order.
My lord, Mr. Pal is the conducting counsel here, my lord.
No, you said that you have not received the paper book.
Paper
No,
book
my
is
lord,
not.
The
we have
paper
not
book
received
has
the
not
paper.
been prepared, madam. So where from you will get the paper book? Office has not yet prepared the paper book.
My lord, may can this matter be taken up next week, my lord? My lord's convenience, my lord.
No, it's all right. But you see, you were engaged and we asked you that you say that who is to be engaged.
My
And
lord,
you engaged
my lord,
Mr.
today there
asked
is some
Mr. Javid
inconvenience.
Pal
Not
to be
well.
the
Conducting
counsel.
counsel is not
Here
well.
to have
And
this
now
That's why I'm
Mr.
requesting
Pal
it.
is to argue the matter. And twice the time has been taken for arguing the bail application.
I understand, my lord. My lord, the conducting counsel is not well, my lord, for which I'm
All right.
requesting my lord's
You want it next week or a week after?
a week after.
Okay. Ms. Orolina Pal, Land Counsel, appearing on behalf of Mr. Joydeep Pal, when amicus curiae submits that the matter may be taken off a week after. It will IA number so and so. This is an application for bail. So let it come on 25th. 20th of next.
Item number 10.
May I please the list for appellant. 156 days delay. So the delay may be condoned and the appeal may be admitted.
ଆପଣଙ୍କ ନାଁ କଣ?
ଲିଜା ଭଞ୍ଜଦେବ।
ଈଶା ଭଞ୍ଜ।
What are the offenses under which the appellant has been found guilty?
Under section 302, 506 and 34 of IPC.
Sentences? What sentence has been imposed on the appellant?
For life conviction and a 10,000 fine.
That is for 302. Okay. All right. IA number 658 of condonation of delay. The stamp reporter has pointed out that there is delay of 179 days in filing this criminal appeal. Considering the submission made by the London Council for the respective parties, the amendments taken in the interim application, and since the appellant petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned. Hard admit call for the trial court report. Interim applications for bail and stabilization of fine to be considered after receipt of the trial court report. Yes. What is your name, confidence?
Lijia Vanjade.
Not looking.
Number 11.
Okay.
This petition has been filed below, saying to court the vigilance case. And for confiscation case number 7 of 2012, under section 13 of the Special Courts Act. Your Lordship had called for a report about the status of the. That report has come. I have not seen that report has come as it appears from the.
Third way.
The Vigilance.
Flag Q. First one to flag status reported flag Q.
Very good. File ଚାଲିଛି।
As it appears that the proceeding has already, the witnesses are being examined.
SP has to be examined.
So,
Cross-examined.
so at this stage, where is the question of, like you are challenging a rejection of the the discharge petition after, and in the meantime, almost most of the prosecution witnesses have been examined.
Last SP has to be examined as per the report.
So it has view
What
of the
I am saying,
status
Lord,
report.
my only submission is I am only on the question of jurisdiction. That's all.
That can be raised there
At the time of trial. Yeah, Lordship is correct. All the points I have taken here can be taken there, but only on the question of this. Because I had filed it in 16, and this matter had come before your Lordship. Yes, to certain extent, certain disputes were settled, decided. It only went back for deciding
now,
whether.
Since there is no stay, so
Yes,
the trial
it has proceeded. It has proceeded.
No, you had filed it in 2016.
Yes, ma'am.
First date, none appears. Second date was in 2025.
Then no step has also been taken from there.
This case.
Yes,
Bosant Kumar Dhara.
2016 ପରେ अपन फाइल कर देले एटा तापरे आसिला
2019
डेप्यूटी रजिस्टर पाखरे 2019 रे आसिला सेतोले डिफेक्ट पॉइंटेड आउट बाय दी नॉट रिमूव तापरे आसिला 2025 रे 16 1 2025
एडमिशन भी आसिला
नहीं एडमिशन के डिफेक्ट रिमूव हेनी आपण
but I file करले dispensing with
हां तापरे फर्स्ट टाइम आसिला 2025 16 1 2025 रे in the meantime so
because of efflux of time the evidence has almost come to an end as per the report
that is the report
that is
this year
but only I pray that Lordship may permit to take all these points and he will decide it without prejudice to the disposal.
The petitioner
we are not going into merits.
Vashant Kumar Paul has filed this CRLMP challenging the order dated 16/2/2016 passed by the Land Authorized Officer, Special Court Bhubaneswar in CC number 7 of 2012. As for order dated 3/3/2025, the Land Authorized Officer has filed the status report from which it reveals that number of witnesses have been examined and the said petition was reaching that order dated the memo was filed to examine
SP Vigilance
Kumar Das, SP Vigilance Kotak in place of so-and-so. Order dated so that is said date even though so-and-so was present or did not cross-examine. Now the so-and-so evidence for Asha. And now the case is at the stage of examination of one Mr. Ranjan Kumar Das, Superintendent of Police, Vigilance Cutter, and though the chief examination is already over, but the petitioner the counsel for the petitioner has sought for time to cross-examine. In view of the status report furnished by the learned authorized officer, we are not inclined to interfere with the impugned order under Annexure 1. However, the petitioner is at liberty to take all the points raised in this CRLNP before the authorized officer at appropriate stage. With such observation,
This 16, Your Lordship, without being influenced by 16.2, he has already held that it is not. So let him decide independently without being influenced by.
ସେଇଟା ଗୋଟେ ପ୍ରଥମ ଷ୍ଟେଜ ବର୍ତ୍ତମାନ ତ
Final stage.
ସାକ୍ଷୀ
Final stage, yes.
ସାକ୍ଷୀ
No,
evidence
to take this point of jurisdiction. To this,
during final adjudication, not being influenced by the impugned order dated 16 to 2016.
Much older.
We have not gone into merits.
It is made clear that we have not gone to the merits of the. Yes.
Item 12.
What we have called to similar report be called for in the line session judge for the purpose of so and so.
Archie.
Was not become it could not be found. Convict was shifted to Chaudhar jail on 3/5/2011. Convict was apprised of Ajaita Achi, report as right to prefer the appeal.
The last two lines, first page of the account.
Last two lines.
Huh.
Please come here. It a ticket here. Are you live streaming that ticket? He visited the jail house to also interacted with the petitioner Servicer Wayne. During interaction, Senator stated that he was unable to file any appeal due to inaction of his lawyers. It said revealed that on grounds of the prisoners had voluntarily stated file appeal from outside with the help of the private counsel. So he was apprised about his right of filing appeal both by jail authority and jail visiting official, but he declined the request. He further intimated the judgment copy of Swan's on. In the meantime, jail authority has recommended the premature release on Swans and further reminded Swans to get further review and because further because the activities will be.
ସେଇଟା ତ ଠିକ ଅଛି ଯେ ପ୍ରିଭିୟସ୍ କେସଟା ଗଲା ଯେ ଆଉ ଗୋଟେ ମାନେ WBS ଲେଭେଲ ଭାଇ କହିଥିଲା କଣ ମନେ ଅଛି ପୂର୍ବ କେସଟା
ନା କରିଦେଇଛି ସେତେବେଳେ ମନା କରିଦେଲା ଜଜମେଣ୍ଟ ଗୁଡାକ ରଖିଦେଇଛି
ନା ଏଇଟା ସବସିକ୍ୱେଣ୍ଟ କହିଲି ଏଇଟା ଯୋଉ ପ୍ରିଭିୟସଲି ଆମେ ଡିସ୍ପୋଜ ଅଫ୍ କଲୁ ସେଇଟା କଣ ଫାଇଲ କରିଥିଲା ତାପରେ नहीं मैम छाड़ दीजिए
ଦେଖନ୍ତୁ JCR
ତା କେସ୍ ଟା ବି କଣ ରିକମେଣ୍ଡ ହେଇଛି ରେମିଶନ
ହଁ
ପଠା ହେଇଛି ସେତେବେଳେ ଜଣା ପଡିଲା ଯେ ଅପିଲ ଫାଇଲ ହେଇନି ତାପରେ ଫାଇଲ ହେଲା ଆଉ
JCRL number 24 of 2025 as per the order dated 18 to 2025 the Land Session Judge Qatar has submitted a report dated 28 to 2025 wherein the reasons has been assigned as to why the jail criminal appeal could not be preferred earlier. It is further stated that the jail authority has recommended the name of the petitioner for premature release on 26/2024. In view of after going through the report furnished by the Land Session Judge Qatar, we are inclined to condone the delay in filing the jail criminal appeal. Accordingly, the delay is condoned or admit call for the trial court record. The Learning Council for the state shall apprise this court about the result of the recommendation made by the jail authority for premature release
on
on 26/2020. Free copy of the order be handed over to the Learning Council for the state. अच्छा
କେବେ ଲିଷ୍ଟ କରିବ
engage करिए
କେବେ ଲିଷ୍ଟ କରିବ ପଛରେ ଯୋଉ ବସିଛନ୍ତି ପଚାରିଲେ ସେ କେତେ
लोगों को पूछिए
हाँ how many years of practice କେବେ କେବେ ରଖିବା ଏଟା ଡେଟ୍
এটা formally देता नहीं चलिए बताऊं कौन आएगा तो केवल
हाँ ଆଉ ହେଇଯାଇଥିଲେ ବି ଅଟୋମେଟିକଲି ସବୁ ଆସିଯିବା କଥା ଇଣ୍ଟିମେସନ ଟା ପଡିବ
Call for the surrender certificate. Yeah, see the paperwork I have yesterday I have received paperwork. Next week I will do my.
This item you are ready. 13. You are ready in item number 13.
କାଲି ବି ରେଡି ହବ
Under 1234 on the allegation of having committed house trespass by entering into the dwelling house of Sumitra Lenka.
My lord.
So Sumitra Lenka is related to you?
No.
No.
But fact of the case is that there is an allegation against me that had committed rape on the daughter-in-law of the deceased. She lodged an FIR against him in 2011. So thereafter, there is a persistent threat. It is alleged that this appellant was threatening the family members. This victim that you to withdraw the case. I was inside the case. After 2 years, in 2013, the deceased died. When the that victim and her husband, माने बहु आउ ता पुओ दि जण एब्सेंट थिले सासु थिले एका घरे subsequently on the next day they got information that that lady died. So that only that on suspect mallet I was arrested.
Lady died माने जागो रेप करथिले?
No, तार बहु को रेप करथिले बहु